So just give me 1 second, and then we will address housekeeping, and I'll swear you all in. So just give me 1 second. Okay, before we move to housekeeping and your substantive motions, I'm going to have all my advocates raise your right hand. Please indicate by saying "I do" if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
All right, and with that, we will call case number 082263, Cam Donaldson versus Karen Baja. I will start with the plaintiff first with your housekeeping matters, whenever you're ready.
Yes, Your Honor. As we've not had the privilege of practicing in your court, we just had a couple of housekeeping matters. First and foremost, we just want to confirm that the court does have a copy of the parties' stipulations within the materials that were provided.
I do. It would be helpful if we need to talk about any specific one, if you can direct me to that. But I do have a copy of the entire case file along with exhibits.
Yes, Your Honor. Also, just pursuant to Local Rule 44, I just want to notify the court that my co-counsel and I will be communicating using an app on our iPad called Google Hangouts. Only him and I are on this channel. We just want to let you know what we're doing.
Yeah.
Also, throughout today's trial, Your Honor, we plan to use the share screen function for exhibits. We just want to make sure that we have the permission to do so. And we will only do so, obviously, once it has been permitted by the court, other than during openings for evidence that we feel will be admitted, have a good faith basis for it, and during closings for evidence that obviously has been admitted.
You can freely, this goes for both sides, feel free to use the share screen function freely. Obviously ask to publish any exhibits that need to be published, but everyone should have access to share screen function. Also for the defense, I have no issue and will not judge if I see you on your phone texting. I understand that that's how people are having to communicate now. So I will not judge you for being on your phones.
Yes, Your Honor. We should notify the court that if there are any technical difficulties, we hope there aren't, but if there are, we have a tech advocate by the name of Peter Calderola who will work very quickly to resolve them if anything does happen. Also, in regards to the space limitations that we are under here, we will be utilizing this room for the advocate who is addressing the court. Therefore, whenever that does switch, we'll just need to be able to rename this little box that you see here for the advocate that's in front of you. And I believe we should have the permission to do that. I just wanted to let you know so that it's not confusing. Additionally, Your Honor, as the court has issued timelines in today's case, may we assume that the witnesses have all been constructively sworn in?
All witnesses have been sworn in.
In Your Honor, because of the manner that this trial is being conducted, may we assume that all sidebars, when requested, will be made constructively outside the presence of the jury?
That's fine.
And may we just assume that all the jury instructions have been read prior to closing arguments?
So you can reference them? Yes.
Thank you, Your Honor. Plaintiff has no further housekeeping matters at this time. We stand ready for substantive motions whenever you're ready.
Okay, we'll get to those after the defense housekeeping. Defense, any housekeeping matters?
Yes, Your Honor. May we request that Your Honor and jurors choose the side-by-side view under the viewing option so that Your Honor and the jurors can see the exhibits and the advocate at the same time?
So we've had some issues with this. Some of us are only able to do the gallery. It doesn't give me an option to do anything more specific than gallery. I'll keep playing with it. This is the best I can do for now, but we've had some issues with, I think it's some people's just computers only allow us to do this, but I will continue to play with that and try to make that happen for everyone.
Okay, I have a brief PowerPoint if anybody needs instructions on how to do the side-by-side view, or we can just move on.
I don't need a PowerPoint, but if you want to try to walk me through it, I'd love that.
Okay, great. Ms. Ward, would you mind walking us through?
Not a problem. So when someone begins to share their screen, you will see at the very top of your screen a drop-down menu, View Options, and you'll click on that and it will be the very last option. It should just say side by side, and that'll give you the ability to see the exhibit as well as the advocate.
Okay, when the first screen share happens, if I'm not able to make it work, I'll chime in and ask someone if we can figure it out. Great. I'm fairly tech savvy. I've done a lot of these real trials, so I'll give it my best shot. But thank you for that. I'll make that note and try to figure it out.
Thank you. Would Your Honor like us to formally tender our expert witnesses?
I would, please.
And last, Your Honor, during direct and cross, would you like the opposing objecting counsel to keep their camera on as well?
I don't, that's personal preference. Honestly, I don't care if that's easier. So you can respond quickly. That's fine with me. But generally speaking, I think it's fine if everyone's just off so we can focus on the advocate, but I don't really have a strong preference one way or the other. So whatever's comfortable to you all.
Thank you, Your Honor. We're ready to move to substantive matters as well.
Okay, great. Ms. Samant, when you're ready.
Yes, Your Honor. We have two preliminary substantive matters. The first being, it is undisputed, Your Honor, in this case that a declaration of death was filed in a probate court of Statesville on August 18th, 2017. It was filed by the defendant, Karen Beja, and it was subsequently granted. This has been admitted to through a judicial admission in the defendant's answer as well. Now, the result of this declaration of death is a presumption that Lou Donaldson is in fact dead. Under Federal Rule of Evidence 301, when such a presumption exists, the party against whom the presumption is directed, in this case, that would be the defendant, has the burden of producing evidence to rebut this presumption. So, Your Honor, we would say that Lou Donaldson being dead is a fact in this case, and therefore the initial element of our cause of action is met, and it must be rebutted by the defendant.
Okay, what's the response from the defense on the argument that there's a presumption that Lou Donaldson is dead?
Your Honor, opposing counsel is correct. It is uncontested that Mr. Donaldson was legally declared dead 5 years after he disappeared. However, that does not mean that he is actually dead. There is a high amount of circumstantial evidence that would lead one to believe that he could still be alive or is still alive. And that is a matter for the jury to decide. So, Your Honor, we would request that you do not take up that Mr. Donaldson is actually dead or presumed to be dead.
Ms. Samant, since this is your motion, I'll give you the last word on this.
Yes, Your Honor. My motion goes to Federal Rule of Evidence 301, which essentially states that there is a presumption in civil cases generally when something like this were to happen. That presumption is then pushed to the defense, in this case, to rebut by producing evidence that Lou Donaldson is not dead, to disprove the fact that he is dead. We would ask that simply saying that he's not or making guesses to the contrary is not sufficient under Federal Rule of Evidence 301.
All right, thank you. So I understand the argument. I understand Rule 304. I'm not going to flip the burden on the defense to show or to switch that burden. I certainly think that you have the argument that Mr. Donaldson has been declared legally dead. That's why the insurance payout happened, but I'm not going to flip the presumption. It's a good, interesting argument, but I'm going to deny your motion at this time.
Yes, Your Honor. Our other motion in limine has to do with the a testimony of an unavailable witness by the name of Carl Bannister. That's the defendant's brother in this case, and he is stipulated to be unavailable. We would move to exclude any mention of this testimony, as a large part of it, in fact, the majority, is needlessly cumulative. The testimony elicited can be elicited, and I anticipate will be elicited through other witnesses throughout this trial.
Okay, what is your response to the 403 objection to Carl Bannister?
The defense does not intend to introduce Carl Bannister's deposition today.
Okay, then, by stipulation, we will not be talking about Carl Bannister then.
Your Honor, this concludes our preliminary substantive matters. Plaintiff stands ready to open.
All right. Ms. Ward, or Ms. Dugan, are you going to be doing motions in limine for the defense?
Yes, Your Honor, I'll be doing one, and my co-counsel will be doing one as well.
Okay.
Our first is defense argues the best evidence rule. We anticipate plaintiffs will want to speak about another alleged will for Lou Donaldson. That will has never been found or verified, and neither an original or a copy will be present in court today. So we ask that under the best evidence rule, any mention of another will be excluded from trial today.
Okay, and what's the plaintiff's position on the other will, the lost will, under the best evidence rule?
Your Honor, I just want to clarify that opposing counsel is referring to Federal Rule of Evidence 1002. I know that's kind of the section for this type of evidence. We have no intention of getting into the contents of this will, and that's primarily what the best evidence rule is aimed towards, is to ensure that specifically if you're going to use a writing, recording, or photograph in order to prove its contents, that you would want the best evidence such as the document. We have no intention of getting into the contents, simply the fact that the plaintiff has personal knowledge through years of working with her father that he did in fact have another will, and that will is what she knows it to be, but nothing about the contents within the will, Your Honor.
Will you not be getting into the fact that he thought it was split 4 ways?
Your Honor.
Okay, based on that representation, do you still have an argument? Do you still have a objection to this, or do you want there to be no mention of this will at all?
I would prefer no mention of the will at all.
Well, of course.
My argument for that, again, is the best evidence rule. Just even talking about the fact that another will may have possibly existed really leads to a presumption of what's in that will, or what did that will mean? And if Cam testifies that there was another will, and without talking about the contents of the other will, how will the jury be able to decide on the legitimacy of it without a copy?
As a motion in limine, I'm not going to exclude mention of the will as of now, assuming that proper foundation can be laid through Mr. Donaldson, that he had knowledge of this will. I'm inclined to allow it, so I'm not going to exclude this will at this time. I think the best evidence rule is cured by Ms. Samont's representation that they're not going into the contents of the will, just the fact that he thought there was another will. I think the jury should certainly weigh that in context with the fact that there's maybe a forgery. So this time I'm not going to exclude it. Obviously, if foundation can't be laid, or if this becomes speculative, we can address this. So feel free to renew your motion, but at this time I'm not going to exclude the will.
Thank you, Your Honor.
Your Honor, may I? The defense also anticipates that the plaintiff will want to mention statements from a woman named Samantha Lane, as well as a letter that they purport Ms. Lane wrote. These statements pertain to whether she did or did not willfully sign the will in question today, and did and did not witness Mr. Donaldson sign that will. Your Honor, Samantha Lane is not available for trial, and no one has been able to verify whether or not she wrote that letter. Therefore, under Rule 801 of hearsay, or Rule 801 of the Federal Rules of Evidence, these statements are hearsay, and we would request that they be excluded from today's trial.
All right, Ms. Simone, what's your position on Samantha Ward's statement as it pertains to hearsay?
Your Honor, I just want to confirm, is it the letter or any statement by Samantha Lane that defense counsel is wanting to exclude?
It would be both the letter and any statement from Samantha Lane.
Yes, Your Honor, so I'll take them in that order. The statements by Samantha Lane were relied upon by both experts in this case, and they will be able to lay a sufficient foundation for the jury to understand, specifically under Federal Rule of Evidence 703, that they relied on these statements, and the probative value in helping the jury analyze or evaluate the expert's opinion would far outweigh any sort of prejudicial danger. Furthermore, in regards to the letter, Your Honor, it's very important for the jury to be able to hear Samantha Lane, just by way of fact. It is disputed whether or not Samantha Lane willfully signed the will that you'll see in court today, or was coerced into doing so. Both experts spoke to Samantha Lane, and the defense expert not only spoke to her, but received a letter. The defense expert specifically disregarded the letter, and my co-counsel during the trial will be able to lay sufficient foundation to show that this goes not only to the credibility of the witness, Samantha Lane, but the credibility of the defendant, Chris Renard. And credibility is always an issue for the jury to take up, Your Honor. Therefore, we would say that the statements, if proper foundation is laid, should be allowed to be discussed.
Ms. Ward, since this is your motion, I'll give you the last word.
Yes, Your Honor. Although experts may rely on hearsay testimony to come to their conclusions, to present those things to the jury, they must be substantially more probative than prejudicial. And in this case, Ms. Lane's statements and the letter are substantially more prejudicial than they are probative. Her statements are more prejudicial because Ms. Lane is not here today for the defense to cross her and for the jury to be able to hear any full story from Samantha Lane. The letter is substantially more prejudicial than probative because no one knows if Ms. Lane truly wrote this letter. So to enter it into evidence, it's any evidence that she was coerced into signing this will without being able to speak to Ms. Lane and get to the truth of who wrote the letter, whether or not it was actually her, is substantially prejudices the defense, Your Honor.
Didn't your expert, Mr. Renard, speak to her or conduct an investigation and rely on this, though?
Our witness, or excuse me, our expert did not rely on her letter to come to his conclusion. It was not for the truth of the matter asserted that he was looking at the letter and that he used the letter. In fact, he does not believe the contents of the letter.
Okay. I am going to reserve ruling on this. I do think that there's a good argument to be made that since both experts relied on this, either party should feel free to cross-examine the experts on how that did or did not impact the report. Obviously, if it didn't impact a report, that's necessary for the jury to hear. If it did, that's also helpful. But I don't know how this is going to play out and if sufficient foundation is going to be able to be laid. So for now, I'm going to reserve ruling on this and see how the evidence plays out. Does anyone reference this in their opening statement?
Your Honor, one moment, Your Honor.
Okay.
If Your Honor would prefer that we don't, we will not. Let me just say that.
To the extent possible, if we cannot mention this in opening, since we don't know if it's going to come in, then I would prefer that.
Yes, Your Honor. We will abide by your ruling.
All right. Any other substantive matters that we need to address?
None from the defense, Your Honor.
Okay, great. Are the parties ready to proceed to opening statements?
Yes, Your Honor. If we may just have one quick moment, and my co-counsel will be ready to open shortly.
All right. Whenever you are ready, the well is yours.
May I proceed, Your Honor? Your Honor, may I proceed?
You may.
Forgery, fraud, fortune. That's what this case is about. Forgery, fraud, and the defendant stealing Lou Donaldson's fortune. In August of 2012, shouts and screams are heard coming from an office on the sanctuary Wild Wildlife. It's a heated fight between Lou Donaldson and the defendant, Lou Donaldson's second wife, Karen Baja. The fight is loud and it is intense. Lou Donaldson tells the defendant he wants a divorce. The defendant storms out of that office and she is furious. Lou follows shortly after, visibly shaken. He says to his daughter, "If anything ever happens to me..."
Objection, Your Honor, hearsay.
Overruled.
He says to his daughter, "If anything ever happens to me, be sure to have the police look into Karen, because she'll be the one responsible for my death." Lou Donaldson disappears only 2 weeks later, never to be seen again. My name is Eddie Villarreal. I, along with my co-counsel, Jushri Samant, represent Cam Donaldson, the plaintiff in this case. I'd like to ask Cam to join us for just a moment so the members of the jury can see her. Members of the jury, this is Cam Donaldson. She is the plaintiff in today's case. Thank you, Ms. Donaldson. Today, you will learn that in 2012, Cam lost her father, Lou, at the hands of the defendant. Today, you'll learn a little bit about Lou, and you'll learn that he was a self-made man. He was a good man, and he worked hard. He started off with very little, but he was able to start his own used car sales business, and he quickly made a fortune. You'll also learn that in 2001, Lou shocked everyone when he left Cam's mom and married a woman 20 years younger than him, the defendant, Karen Basha. It was a tough transition, but Cam made it work. See, part of what kept Lou Donaldson and the defendant together was their love of animals. Cam loved big cats. He loved big cat. He loved tigers, lions, leopards, and the like. And although he was good at selling used cars, animals were his true passion. So when he was able to make enough money, he started a sanctuary for big cats called Wild Wildlife, and he grew that sanctuary into a $5 million business. And today you'll get to know a little bit about Cam as well, and she will testify about this relationship that she and her father shared. She would testify that through childhood, their relationship flourished, but it was even stronger during the time that they worked at the sanctuary together. See, today you'll learn that Cam was Lou Donaldson's assistant for several decades. And they shared the same relationship. They shared this relationship up until the last day that Lou was seen alive. You'll learn that on that day, Lou invited Cam over for Sunday dinner. And if not, they'd see each other on Monday. But you will learn that that Sunday dinner never happened. And today, we will prove to you that that Sunday dinner never happened because of the defendant, Karen Basha. As the plaintiff, we have the burden of proof in this case, and our burden of proof is by preponderance of the evidence. That's really just a complicated way of saying more likely than not. See, what we will prove to you today is that it's more likely than not that the defendant caused Lou Donaldson's death, and Lou Donaldson's death caused Cam Donaldson harm. The first thing we will prove is that Lou Donaldson is dead. And the evidence will show that Lou Donaldson has not been seen since 2012. And his bank account hasn't been touched since before his disappearance. Taylor Pride, a private investigator and forensic document examiner, will testify today about her investigation into this bank account. And she will explain how the overwhelming evidence proves that Lou Donaldson is dead. We anticipate that the defense will attempt to argue that maybe Lou Donaldson is alive, living off in Costa Rica with a mistress. But even the defendant will have to admit that she asked the court to declare Lou Donaldson legally dead. The next thing we will prove to you is that the defendant either intentionally or recklessly caused Lou Donaldson's death. The evidence will show that the defendant had the means, had the opportunity, had the ability to make Lou Donaldson disappear forever. Today, you will learn that on the night that Lou Donaldson disappeared, the defendant was conveniently away from her cell phone so that her whereabouts could not be tracked. The evidence will show that the defendant had the means to dispose of the body and the help to get it done. See, Lou Donaldson's death, it left the defendant filthy rich. In the wake of Lou Donaldson's death, you will hear that the defendant produced a will that left everything to her and nothing to Lou's family and nothing to these cats that Lou loved so dearly. That will, it left everything to her. But when Taylor Pride testifies today, Taylor Pride will testify that this will is fake. Taylor Pride will take you through a step-by-step analysis, and she will show you this signature. The defense's own witness will have to testify that some of the language in this will is suspicious, and that it's possible this signature on the will is forged. Forgery, fraud, fortune. That's what this case is about. See, when the defendant killed Lou Donaldson, she destroyed a family. And she robbed Cam Donaldson of her father. She robbed Cam Donaldson of her mentor and a friend. And today, we'll ask you to compensate Cam for just a little bit of all that she's lost. We'll ask that you not allow the defendant to walk away with this fortune that she wrongfully obtained through a forgery and a fraud. Today, we will ask you at the end of this trial that you return the only just verdict and find the defendant liable for causing Lou Donaldson's death. Thank you.
Thank you. Defense, whenever you're ready, you can proceed with your opening.
Thank you, Your Honor. It's the early morning of August 19th, 2012, and Karen Baja is tired and alone. Her stomach sinks. Her husband, Lou Donaldson, is not home. This would be far from the first time she's been left home alone, unsure of Lou's whereabouts, but Karen knows this time Lou isn't coming back. Karen knows that Lou has finally left her. She didn't want to believe it, but the signs were all there. You learn about the mistress in Costa Rica, the talks of divorce, the will he left behind should he disappear. Lou Donaldson vanished, and he did so because he wanted to. But things hadn't always been so shaky. Once upon a time, Karen and Lou had lived a fairy tale. They'd met and fallen in love at first sight. They'd been married for 11 years. Before he met Karen, Lou opened Wild Wild Life Tiger Emporium for big cats. Karen fell in love with those cats just as quickly as she'd fallen in love with Lou. She worked with them, and eventually Lou made her a co-owner. For 11 years, they worked together, and they lived together, and they loved together. But all fairy tales come to an end. Theirs did when Lou chose to leave. Lou Donaldson vanished into thin air, and to most people, it didn't make sense. Not only did he have a good life, he had the kind of life that people envy. He had a close relationship with his daughter, Cam. He had a younger and dutiful wife in Karen. He had a majorly successful business with Wild Wild Life. Lou had every reason to be where he was supposed to be. And if his disappearance was a mystery, the way in which he disappeared was an even bigger mystery. Lou seemed to be in the middle of a few things, and then suddenly he was gone. He had deposited some money into a bank account, made plans with Cam, left behind a will. To most people, those things don't seem like a man planning to leave his family. But Lou Donaldson was not most people. In his circle, he was well known for his rags to riches story, going from a used car salesman to a multimillionaire with a love for airplanes. But he was also known for his eccentricities, for making choices that almost never made sense, that almost never added up. Lou made choices that no one else could really explain, so long as those choices got him what he wanted. This was a kind of a man who met a hitchhiker, took her to a motel, and married her. This was the kind of a man who decided he would spend the rest of his life caring for big cats. This was the kind of a man who would fly without a license and not tell anyone where he was going. And in making those choices, all for the thrill of what he wanted, Lou Donaldson was the kind of a man who made others deal with the consequences of his actions, who expected everyone else to honor whatever choice he had made. For example, when he married Karen, that hitchhiker, he did so without thinking of anyone else. His family, Cam included, never liked Karen, and they never kept that a secret. But Lou had made his choice. He wanted a new wife, and it was up to everyone else to honor that choice. To keep his wildlife emporium running, Lou used the labor of his family. For 20 years, Cam did all the hard desk work. She ran the books, she scheduled the meetings, she answered the phone, and Karen did all the hard animal work. She protected the animals. She nursed them in the dead of the night. She cared for them. Wild wildlife was Lou's in name only. The burden of keeping that up was on his family. Lou had made his choice. He wanted a big cat sanctuary, and it was up to everyone else to honor that choice. When he would fly off, mysterious as it was, he wouldn't tell Karen, leaving her to worry and stress. Lou had made his choice. He wanted to fly in peace, and it was up to everyone else to honor that choice. You'll learn today that Lou loved to fly to Costa Rica, and you'll learn that he loved to fly there for a reason. You'll learn that he had a mistress there, that he was seeking a divorce from Karen, that he had the words, "If I die or disappear," included in his will before doing just that. You're going to learn today that yet again, Lou Donaldson had made his choice. He wanted a new life. And as always, he was leaving it up to everyone else to honor that choice. Lou Donaldson hadn't disappeared. He'd left. And he'd done so because he wanted to. In the early hours of August 19th, 2012, Karen Baja knows this. She knows that her husband has finally left, and she knows that he's probably not coming back. She also knows what she has to do now. Go to the Emporium, get the lockbox, and let go of Cam. Because Karen knows that with Lou gone, she and Cam can no longer work side by side. Karen knows that Cam's hatred of her could ruin wildlife. So she lets her go. And in the months and years that follow, Karen Baja waits for a phone call or a postcard, something from Lou so she knows that he made it okay. But 5 years come and go. Her husband is gone. But his love, wildlife, that remains. So Karen makes a difficult choice. She has Lou pronounced legally dead and collects the life insurance that he left for her. And with that money, she can keep wildlife running. Even after he's left her, Karen is still honoring Lou's love for big cats and his decision to leave. But Cam Donaldson has a harder time honoring her father's choice. Lou's ultimate act of inconsideration was leaving Karen his business and his life insurance. That's the reason we're really here today. Cam Donaldson did work for her father for 20 years. Her father was worth millions of dollars. It only makes sense that she would expect something from Lou. But you'll learn that this was not Lou's vision. You'll learn that Lou left everything to Karen to prepare for a new life. That yes, he wanted to leave, but he didn't want his cats to go uncared for. You'll learn that Lou knew Karen loved those cats and knew how to take care of them, and that he left her enough money to do just that. That must be a blow to Cam. And now, unable to look the hurtful truth in the face, Cam has brought us here today to place the blame on the wrong person and try to avoid honoring her father's choice. Today, Cam has brought to you a claim of wrongful death against Karen Baja, seeking monetary relief for damages she claims Karen caused her. Members of the jury, the plaintiff has the burden of proving their claims by a preponderance of the evidence, meaning it's more likely than not true what they tell you today happened. The plaintiff is going to tell you a lot, but there are a few things you must believe in order to find in their favor. That Lou Donaldson is dead. That Karen, either intentionally or recklessly, caused his death. That Cam suffered injuries, damages, or losses as a result of her father's death. And that Karen's conduct, either intentional or reckless, were the cause of Cam's injuries. And if you don't believe one of those four, you cannot find in favor of the plaintiff. We're going to tell you a lot today too, but there are some things we can't fill in, just the same as the plaintiff. We cannot tell you if Lou Donaldson is dead. You will learn today that his body was never recovered, that there's no physical evidence suggesting he's dead, and that there's no evidence suggesting he was murdered, least of all by Karen. We can't even tell you where he is, if he ever made it to Costa Rica, or if he perished in the ocean on his way there. What we will be able to tell you today is this: Lou Donaldson vanished, and he did so because he wanted to. What we will be able to tell you is this: in vanishing, he left his loved ones to honor his choices like he always did. When you hear from Chris Renard, an expert in forensic document examination, and a man who makes a living ensuring fraudsters don't get paid out on illegitimate insurance claims, you will learn that Lou Donaldson was in fact the person who signed his will that left everything to Karen should he disappear. You'll learn that there was no reason to contest Karen's claim for that insurance payout, and that the insurance company would not have honored the will or the claim otherwise. And when you hear from Karen Baja, you'll learn that she was a wife who wanted to stick by her husband's side, despite his affair, despite the fact that he had asked for a restraining order against her that even a judge couldn't approve. You'll learn that she was a wife who honored whatever eccentric choice Lou made when he was with her, and even after he left her. And now, members of the jury, we're here, trying to make sense of what Lou left behind. But in order to do that, we must work with what we know. And we do not know if Lou Donaldson is dead. But we do know that he has vanished. And by the end of this trial, you will know that Lou Donaldson vanished because he wanted to. By the end of this trial, you will know that Lou made eccentric choices and expected everyone around him to honor those choices. That this is just another example of that behavior. We'll ask that you remember that. We'll ask that you remember that as he prepared for a new life in Costa Rica, as he started up his plane and took off for that life, Lou made yet another eccentric choice. That we cannot know why he didn't consider Cam or Karen, only that he chose to leave, only that he hoped his choices would be honored. And that Karen, whether she agrees with him or not, has been honoring Lou's choice, and that we all must, you, the jury, included. At the end of this trial, we'll ask that you find Karen is not responsible for Lou's disappearance. Lou Donaldson vanished because he wanted to, and we all must honor that choice. Thank you.
All right, thank you. Would the plaintiff like to call their first witness?
One moment to switch to my co-counsel, Your Honor.
Sure.
Thank you.
Your Honor, plaintiff calls witness Cam Donaldson to the stand.
All right, Ms. Donaldson. Whenever you're ready, the well is yours.
Your Honor. Good afternoon, Ms. Donaldson. Can you please introduce yourself to the members of the jury?
Yes, my name is Cam Donaldson. Lou Donaldson was my father.
Ms. Donaldson, why have you brought this lawsuit?
I've brought this lawsuit because Karen Baja killed my father and robbed
Judge,
me.
Your Honor, facts not an evidence, lack of foundation.
Response.
Your Honor, as to the facts not in evidence, the witness will testify can lay further foundation. However, this is the witness's personal reasons for bringing forth this lawsuit, and these are her beliefs that she is telling the jury today.
All right, overruled.
I'll repeat the question, Ms. Donaldson. Why did you bring this lawsuit?
I brought this lawsuit because Karen Baja killed my father and robbed me of the relationship that we shared.
I'd like to get back to the defendant, but first, can you please tell the members of the jury about your father?
Yes, I loved my father. He was a good man. He was a self-made man. I mean, he built himself up from nothing. He started out selling used cars.
What did your father do for work other than used cars?
So while he started out selling used cars, his real dream, his real passion was for animals. So once he saved up enough money, he actually started his own business called Wild Wild Life.
Can you please tell members of the jury a little bit about Wild Wild Life and what your father did there?
So my father owned Wild Wild Life, and it was a sanctuary for big cats. My father's passion was caring for these animals, and he built it up from the ground. And by the time he was killed, it was worth $5 million.
Objection, Your Honor. Again, to facts, not in evidence. This witness and lack of foundation. This witness has no foundation to say that her father was killed or is even dead, and there's nothing in evidence to suggest that he was killed.
I'm going to overrule the objection. I think that this witness has brought this lawsuit. She's certainly going to testify. I think most of her testimony is going to be laying the foundation for why she believes this. Now, you're certainly entitled to go on cross-examination as to whether or not you think that is a credible belief, and I expect that you will, but I'm going to overrule the objection.
Ms. Donaldson, you mentioned that your father had started Wild Wild Life. Did you ever work there with him?
I did. I actually worked with my father as my father's assistant at Wild Wild Life for 20 years.
What kind of things did you do as your father's assistant for that long?
So I answered phones, I scheduled meetings, just about everything. My father actually always joked that I knew more about the business than he did.
So working so closely with your father for such a long amount of time, what was your relationship with him like?
So my father and I were very close. I mean, on top of working together at Wild Wild Life every day, I would also go and have Sunday suppers with him.
Ms. Donaldson, what happened August 17, 2012?
So that's the day I saw my dad for the very last time. It seemed like just a typical Friday evening. It was about 6 p.m. when he left the office.
You saw him about 6 p.m. Did he mention any plans he had for that weekend?
No, I mean, he didn't say anything about going on any trips. He definitely didn't mention going to Costa Rica or anything like that. In fact, he mentioned that we would have dinner Sunday night.
So you mentioned he didn't say anything about any trips. Had your father taken trips in the past?
So my father was a pilot, and he owned a number of planes. So he would travel, but he always told me when he was leaving.
What other reason do you know that your father didn't go anywhere that weekend?
So after my father disappeared, his van was actually found at some random airstrip like 40 miles away, one that he never flew out of. And in his van were found his glasses and keys. I know he wouldn't fly without those glasses. He was blind as a bat without them.
Ms. Johnson, I want to discuss what happened after your father disappeared. What happened to Wild Wild Life?
So after my father disappeared, Karen Beja came up with some bogus will, and she ended up inheriting Wild Wild Life under that will.
I would refer the court and opposing counsel to what has been Bates marked as ending in 0014 for identification purposes. And I would refer the witness as well. Your Honor, may we have this marked as Plaintiff's Exhibit 1 for identification purposes?
Assuming it gets admitted, yes.
Yes, Your Honor. I'm going to just want to make sure for the court reporter and all that. Ms. Donaldson, please let me know when you've located the exhibit.
I have the exhibit.
Ms. Donaldson, do you recognize this exhibit?
I do.
How do you recognize it?
I've seen it before.
And what do you recognize it to be?
This is the will that Karen Beja came up with.
And is it in the same or substantially the same condition as the last time that you saw it?
Yes, it is.
Your Honor, at this time, plaintiff would offer what has been Bates identified as 0014 into evidence as plaintiff's exhibit 1.
Any objection to plaintiff's 1?
No objection, Your Honor.
All right, plaintiff's 1 shall be admitted and you may publish should you choose to.
Yes, Your Honor, we'll publish at this time using share screen. Your Honor, before I continue with my next question, I apologize. I just wanted to approach for one moment outside the presence of the jury.
Sure, you may.
In regards to the question I'm going to ask the witness, as I said earlier in preliminary matters, I have no intention of getting into the contents of the will that the plaintiff knows to be her father's will. However, I do intend to ask if those two documents are different, and that is my only question. I just, I want to make sure that that is within Your Honor's ruling as far as this matter.
All right, Ms. Ward, what's your position on that?
We would re-raise our best evidence rule if we're going to get into the contents at all, how these wills are different. We can't know how the wills are different if we don't know what was in the other will, and that will is not here with us today, so we would raise a best evidence argument.
Okay, I certainly understand the best evidence argument. My guess, though, is that the plaintiff is going to be arguing that the defendant is responsible for the disappearance of this document, which would certainly be an exception under the best evidence rule. So I'm inclined to allow this, especially in light of just how limited we are going into this, since we're not going to go into too much of the specifics. So I'm going to overrule your objection and will allow the plaintiff to present this evidence.
Yes, Your Honor. They would be back in the presence of the jury.
Yes.
Ms. Donaldson, what are we looking at here on the screen?
So this is the will that Karen Beja claims was my father's.
Had you ever seen this document before the defendant presented it?
No, I had not.
Were you aware of any other documents that you had that your father had used to plan for his future?
Yes, my father had a will. I was aware of it because it was kept in a lockbox in my desk at Wild Wildlife.
Ms. Donaldson, is the will that you're referring to in the lockbox just different from the will that we're seeing here on the screen?
Yes, it is different.
Your Honor, at this time I'd stop sharing the exhibit. Ms. Donaldson, do you still work at Wild Wildlife?
No, I don't. Soon after my father went missing, Karen Beja fired me.
Now, what happened a few days after your father went missing that alerted you to some concern?
So not long after he went missing, actually, just not long after, there was actually the alarm at the Wild Wildlife office was set off. And I live close by, so I went right over there when that happened.
Your Honor, I refer the court and opposing counsel to what has been Bates identified as 004 and 005 for identification purposes. Ms. Donaldson, have you located these two exhibits?
Yes, I have.
Do you recognize these two exhibits?
I do.
How do you recognize these photos?
These photos depict what I saw when I arrived at the Wild Wildlife office.
And what are they photos of?
So the first is a photo of a damaged lock. And then the second is a photo of a damaged gate.
And are these two photos a fair and accurate depiction of the lock and the gate that you claim to have seen at the break-in that night?
Yes, they are.
Your Honor, at this time, plaintiff would offer what has been Bates identified ending in 004 and 005 into evidence as plaintiff's exhibit 2A and 2B.
Any objection to 2A and 2B?
Yes, Your Honor. I object to relevance of 2B. This witness did not actually see that that gate had been opened until later, and we do not know how much later that was. That is not specified. So it is very possible that that gate was not opened the night of the break-in that they're going to contend occurred, and so therefore it's not relevant to this line of questioning if it were not used for that break-in, Your Honor.
Ms. Samant?
Yes, Your Honor. My understanding of defense counsel's argument is that maybe that this witness's testimony isn't sufficient enough. I believe that that goes to the weight of her testimony, not to the admissibility of it. It's relevant because this witness will testify to what she saw at the break-in that night and events following that break-in, Your Honor.
And I think the argument is that we just don't know when this was cut. It could have been cut at any point. Nonetheless, I think that goes to the weight of both of these documents, really, and not their admissibility. You can certainly cross-examine on that and argue that in closing, but I'm going to admit 2A and 2B as plaintiff's exhibits.
Thank you, Your Honor. May I publish to the jury at this time using share screen?
You may. Just one moment. As you guys are doing this, I believe I've got the right side-by-side mode for everyone. Is everyone pleased with their viewing options?
Yes, Your Honor.
Okay, great.
Yeah. May I continue?
You may.
Thank you. Ms. Donaldson, what are we looking at here on the screen?
So the first photo is a photo of the lock that was cut at Wild Wildlife. And the second photo is a picture of damage to a gate at the Wild Wildlife office.
So you mentioned that an alarm went off and you showed up at the scene and you saw these two images. What else did you see at the scene of Wild Wildlife?
So when I got there, Karen Beja was actually coming out of the office carrying the lockbox I mentioned before that contained my father's will.
Ms. Donaldson, the document that you say was in the lockbox, have you ever seen that document since that day?
No, I have not.
Sorry, I'll go ahead and stop sharing exhibit 2A and 2B. Ms. Donaldson, that will that we had presented earlier, how much did the defendant receive as a result of that will?
So she got everything. She got the whole business, Wild Wildlife, which was worth $5 million.
Ms. Donaldson, let's talk about how your father had planned for his future. What assets other than Wild Wildlife did your father have?
So he also had a life insurance policy that I didn't find out about until Karen Beja actually received the proceeds from that, which was also $5 million.
Ms. Donaldson, working so closely with your father and Ms. Beja at Wild Wildlife, what did you experience their marriage to be like?
Well, it wasn't good. They fought a lot, and often I would be there and hear or see that. And in fact, it was so bad that my father wanted a divorce.
How did you know that your father wanted a divorce?
I heard the argument that he and Karen Beja had whenever he told her. She was furious.
What happened after the argument?
So, like I said, she was furious and they were fighting. And she came out of the office and my father followed shortly after, and he was visibly shaken.
How did you know your father was visibly shaken?
I mean, I'd never seen him like that. He was very upset. He was clearly shaken up, and he told me that if anything ever happened to him,
Objection, Your Honor, to hearsay.
Response to hearsay.
Yes, Your Honor. This statement that will be elicited if we're allowed to continue is an exception to hearsay under Federal Rule of Evidence 802 or 803-2 as an excited utterance. We will hear that Lou Donaldson, after an event, the event being this very heated argument with his wife, immediately walked out and then excitedly uttered these words to the plaintiff while he was still under the effects of that argument. Therefore, this is an exemption to hearsay, Your Honor.
Just as an offer of proof, what is this witness going to testify to if allowed?
Yes, Your Honor. If we may be asked in the presence of the jury, this witness is testify to the fact that after this argument, which she overheard, not the specifics, but the general argument, that her father in that argument was essentially telling the defendant that he wanted divorce. The defendant was upset. She walked out furious. The father came outside and said, if anything ever happens to me, have the police look into Karen Beja.
And what purpose are you offering this for?
Your Honor, the reason for this statement is the reliability factor is met, as I said, due to the fact that it's an excited utterance. We have very little from what Lou Donaldson felt and was experiencing around the time shortly before his disappearance. This argument was just a few months before he disappeared, and Lou Donaldson told his daughter of his concerns, and this is the only way the jury could be able to, understand what Mr. Donaldson was going through, especially in regards to the defendant.
All right, Ms. Ward, last word.
Thank you, Your Honor. We do not know if during that argument, Ms. Beja threatened Mr. Donaldson or even was violent toward him. So we cannot know if this statement was actually directly linked to the argument that they had. Therefore, I do not believe it meets the excited utterance exception.
Yeah, I don't think that the foundation's been laid for excited utterance, but based on your representation, Ms. Samant, I think this is certainly admissible under 803.3 in light of the fact that it sounds like you're going to be offering this to demonstrate how he was feeling in the moment and just what he kind of experienced, so his state of mind. So I'm going to allow it for that limited purpose only, that it goes to his state of mind, not that this was necessarily a threat, but that he was fearful and what he experienced prior to the disappearance. And with that limiting instruction, I will allow it.
Yes, Your Honor. Ms. Donaldson, I'll go ahead and repeat the question. You mentioned your father was visibly shaken. How do you know that?
I mean, I'd never seen him like that before. He was clearly very upset. He was clearly shaken. And when he came out, he told me that if anything ever happened to him, to have the police look at Karen Beja because she would be responsible.
Ms. Donaldson, did something happen to your father?
I mean, something happened to him. He's not here, and I know Karen had something to do with it.
Ms. Donaldson, let's discuss why you brought this lawsuit. Why are you bringing this lawsuit against the defendant?
I'm bringing this lawsuit because the defendant killed my father, and she shouldn't be able to reap the benefits of that.
Objection, Your Honor. I do feel that this should be struck. I believe that Ms. Donaldson can say that she felt Karen threatened her or killed her father, but again, she has not laid the foundation to say that Karen killed her father. Her opinion is fine, but stating that as fact, she does not have the foundation to do so.
I think I've already ruled on this, so overruled.
Ms. Donaldson, I just want to repeat the question. Why are you bringing this lawsuit against the defendant?
Because Karen Beja, the defendant, killed my father, and she shouldn't be able to reap the benefits of that.
You're saying that the defendant has taken things away from you. What do you have to remember your father by?
So while my father is gone, I do have one photo.
Referring the court and opposing counsel to what has been Bates marked ending in 003 for identification purposes only. Ms. Donaldson, I refer you to that as well. And if you can please let me know when you've located it.
I have it.
Do you recognize this photo?
I do.
How do you recognize it?
So this is a photo of my father and I when I was younger.
And is this photo in the same or substantially the same condition as when you last saw it?
It is.
Your Honor, at this time, plaintiff would offer into evidence what has been Bates labeled as 003 into evidence as plaintiff's exhibit 3.
Any objection to plaintiff's 3?
No, Your Honor.
Okay. Plaintiff's 3 will be admitted.
Your Honor, may I publish to the jury at this moment using share screen?
You may.
looks like we might have two versions of the same document. I'm not sure if that's maybe my screen messing up or if everyone is seeing it.
It does appear to be a sort of double image, but I think we can see it just fine.
Okay, I'll just go ahead and question on this if that's okay with Your Honor. Ms. Donaldson, what are we looking at in this photo?
So my father, as you can see in the photo, he's spinning me around. This is my favorite photo of the two of us.
How has your father's disappearance affected your day-to-day life?
I mean, I miss my father every single day. I think about him every single day. I miss working with him. I miss our Sunday suppers. It's been devastating.
Ms. Donaldson, I just want to know, what are you asking of the jury today?
So I want the deed to my father's business. He would want me to take care of the cats that we both cared about. I want the proceeds from the life insurance policy. Karen Beja shouldn't get to take that. He wouldn't want her to have that after she killed him. And I think I should be reimbursed for all the suffering that this has caused.
Your Honor, at this time, I'd ask that this photo be taken down. It's not relevant to any line of questioning at this time.
Are we still questioning on this?
I'll go ahead and stop sharing the screen, Your Honor.
Okay, great, thank you.
Ms. Donaldson, what would you be doing today if your father was still here with you?
I mean, the same thing we were doing before he was killed.
Your Honor, speculation. She cannot know what she would be doing in the future.
Spons?
Your Honor, in regards to this witness and the question of what she would be doing if her father was still here, having worked with him for 20 years side by side at the same company and having a daily routine, it's within her purview and her personal knowledge to know that that probably would still be continuing if her father was still here today.
Is this a loss of employment argument for damages or just?
It's a loss of companionship argument, Your Honor.
I certainly think you can ask that question and say, you feel like you've lost companionship. I'm not sure that you need to be asking such a vague question of what would you be doing maybe if he was here. So I'm going to sustain the objection, but I certainly think you can rephrase and probably get to the heart of what you're trying to get to.
Yes, Your Honor. If I could just have a moment. Ms. Donaldson, is your dad here today with you?
No, he's not, and I'll never see him again.
There are no further questions at this time.
Thank you. Cross-examination.
Thank you, Your Honor. Cam, let's talk about what you knew about your father. Lou Donaldson was your father.
Yes.
Your parents were divorced,
Yes.
but you still got to grow up around Lou.
Yes, we were very close.
So you got to know him still.
Yes.
You knew that your dad had a rags to riches story,
Yeah, I guess you could say that.
that he used to be a used car salesman,
He did.
and that's a pretty normal line of work.
Yeah, I guess you could say that.
But your dad's passion was big cats.
Yes,
So he stopped selling cars,
he did.
and he opened up Wild Wildlife Emporium
That's correct.
so that he could take care of big cats.
Yes.
And that might be a little bit unusual.
Yeah, I don't think you see, I don't think you see that all the time.
You also knew that your father was wealthy.
He was eventually, yes.
He was a multimillionaire eventually,
Yes.
and he could afford any car that he wanted.
I guess.
But your dad chose to drive an old conversion van.
Objection, Your Honor. There's relevance to this line of questioning.
Response to relevance.
Your Honor, this line of questioning is relevant. I'm getting to what the witness knew about her father and what the witness knew about her father's his lifestyle and just his general interactions with her.
I'll allow it.
I'll ask that question again, Ms. Donaldson. You knew that your dad chose to drive an old conversion van.
He drove a van. I don't know a whole lot about vehicles.
But him choosing to drive that is a bit unusual.
I have no idea.
Well, you also know that he could afford to go to the doctor.
Just kind of speculation in general here.
I don't think it's speculation. I'll overrule it.
You also knew that he could afford to go to the doctor.
I assume so. I didn't accompany him to the doctor.
Like an eye doctor.
Sure.
But he chose to wear an old pair of glasses.
I guess they were his favorite pair of glasses.
And he had owned those since you were in high school.
That's correct.
Which might be a bit unusual.
I have no idea.
Well, you also know that your dad had a supportive relationship with your mother.
He did.
She used to be his wife.
That's correct.
But your dad chose to marry Karen Baja,
He did.
a woman that he had met on the street.
Yes.
And that was a bit unusual.
I don't know.
These were all the choices that your father made.
Yeah.
And some of them may have been unusual.
I have no idea.
Well, since we're on the subject of the things that you knew about your dad, let's talk about his airplanes. So days after his disappearance, your father's van was found.
Yes.
And it was found in an airstrip,
Yes.
about 40 miles away from Pioneer.
That's correct.
And that was odd to you.
Yeah, I don't think that I know he didn't fly out of that, or from that airstrip.
Well, you think that he didn't hangar his planes at the airstrip.
No, he didn't.
Well, you knew a few things about your dad's planes, excuse me.
Yes,
Mostly you knew that he liked airplanes
he did.
and that he owned some.
Yes, I knew that he owned more than one.
And you knew that he bought and sold planes all the time.
Yes.
But you couldn't keep track of what planes he had.
No, I didn't always know that.
So your father would have planes that you didn't know about.
He may have, yes.
And he had to hangar each one of those planes.
Yeah, I would assume so.
He even had to hangar the planes you didn't know about.
I assume so.
And if you didn't know about an airplane, you couldn't know where it was being hangared.
I don't know.
I want to get into your role in Wild Wild Life. So your father created Wild Wild Life.
He did.
And you worked there.
I did.
For 20 years.
Yes.
You worked very hard.
I did.
You wrote the checks.
Yes.
You did the accounting.
Yes.
You scheduled his meetings.
I did.
You even answered the phone.
That's correct.
You did it all.
I did all of those things, yes.
And your dad even joked that you knew more about the business than he did.
He did.
So if anything happened, you would know how to run the business.
I don't know.
If anything happened, you might be able to keep his business running.
Yeah, I mean, I think that I would be a more logical choice than Karen Beja.
Okay, well, let's talk about the reality of keeping the business running. Your dad loved big cats.
Yes.
So the purpose of Wild Wild Life was to take care of big cats.
That's correct.
To rescue them.
Yes.
To preserve their families.
Yes.
And you weren't your dad's only employee.
I don't know that.
Well, we know that he had hired Karen.
I know that Actually, I don't know that.
And we know that he had zookeepers as well.
I don't know that.
And Karen loved big cats.
I have no knowledge on that subject.
Well, Karen was working with the big cats.
I assume so.
And by the end of the 20 years, you were answering phones still.
I was doing a lot of things.
Yes or no, by the end of 20 years, you were still answering telephones?
That was one of my responsibilities.
And you were still scheduling meetings?
That was another one of my responsibilities.
And another one of your responsibilities was ordering supplies.
That's correct.
And after all that time, you hadn't been taught how to take care of the big cats.
I have no knowledge on that subject.
You don't know that after all that time, you weren't taking care of big cats?
I don't know that, no.
Well, after all that time, you weren't co-owner of Wild Wildlife.
No, I was not.
Instead, Karen was taking care of big cats.
I don't know that.
Instead, you do know that Karen co-owned the business with your father.
I don't know that either.
You don't know that after all that time, Karen was the co-owner of Wild Wildlife?
No.
You, though, were still your dad's desk assistant.
I was my father's assistant.
Let's move into your expectations, Miss Donaldson. You no longer work at Wild Wildlife.
No, Karen fired me after she killed my father.
Right, excuse me. Your Honor, I know that you have ruled on this, but again, this is outside of her basis of knowledge. There's no foundation. And I would ask that her answer be struck and that she respond to my question, which was, you no longer work at Wild Wildlife.
I certainly, I'm not going to strike her answer. I think you can continue to cross-examine her and control the witness without my assistance.
Miss Donaldson, I'm going to ask you one more time, and I'll ask that you answer yes or no and stick to the question that I'm asking you. You no longer work at Wild Wildlife.
No, I don't.
Because you said Karen fired you.
That's correct.
And she now owns that business.
She does.
And you want it back.
I do.
You've stated that you want the deed to Wild Wildlife.
That's correct.
You want ownership to everything at Wild Wildlife.
That's correct.
Because that's what you deserve.
Yeah, I would say that.
And all the proceeds to your dad's life insurance, they also went to Karen.
That's correct.
And you want those as well.
Yes.
Because he was your father.
He was.
And you're here today seeking economic damages, in part.
Yes.
To restore you to a previous economic state.
I mean, I don't know the technical terms, but I think that I should be reimbursed. Yes.
Or to get you to an economic state you anticipated being in.
No, I wouldn't agree with that.
Well, you have no evidence that your father planned to give you the deed to Wild Wildlife.
I do know that I know based on his will, he intended to give me a quarter of it.
Well, Miss Donaldson, that has not been entered into evidence. Your Honor, I will object at this point to lack of foundation and things not entered into evidence because we do not have that document. We have not been able to see the contents of it. And I would ask that this answer be struck.
Ms. Samant, what's your response?
Your Honor, I believe defense counsel's question specifically states that her father was or was not going to give her something. I believe that question is what's calling for the answer in regards to contents of a previous will. It would not be fair for the jury to be able to hear the question about this and then not be able to hear the plaintiff's response as to why she would know that.
Yeah, Ms. Ward, I think your question sort of, and I apologize, I'll give you a chance to respond, but I'll tell you my concern is that I think your question opened the door. You said you don't know that he was going to give you the deed, and I think we know that she thinks he was based on this last will. So I think you may have opened the door, but feel free, tell me why you see it as otherwise.
Well, Your Honor, I'm simply saying that the jury has no evidence in front of them of what her father planned to give her.
Oh, I understand that, but I think when you ask this witness, you have no information about the will. She can certainly say, I think he did. I think you opened the door. You can say, we don't have that will in front of us, we can't compare it, but I think your question opened the door, so I'm going to allow it.
Okay, Your Honor. Well, Ms. Donaldson, let me ask you that again. I'm going to ask it just the same way I just did. We have no evidence that your father planned to give you the deed to Wild Wildlife.
I do know that he intended to give me at least 25% of it.
And 25% of Wild Wildlife is not the entire deed.
No, but considering Miss Beja killed my father,
well, we also have no evidence that your father intended to give you the proceeds of his entire life insurance.
no, I didn't even know about the life insurance until Karen took it.
But you're here asking for everything.
That's correct.
Despite a will that never left you everything.
Karen Beja killed my father.
Let's talk about Karen. She was your father's wife.
Yes.
And he had been married before her.
That's correct.
To your mom.
Yes.
You had a good relationship with your mom.
I assume so.
Your parents had a good relationship.
Sure.
But your parents' relationship didn't stop your dad from marrying Karen.
No, he married Karen.
She was 20 years younger than your father.
Yes.
She came from a poor upbringing.
Yes, she did.
You thought that she was out for money.
I did.
You didn't react well to that new relationship.
No, I thought she was after his money.
You weren't accepting of her.
No, I wasn't.
In fact, you hate her.
I do hate her now. She killed my
But
father.
you worked with Karen.
I'm sorry.
Sorry, was there an objection?
Yes, Your Honor. I would just ask that the defense counsel let the witness complete her answer before asking another question.
I think just for the record's sake, let's just make sure she finishes. I think some of that is just a Zoom issue, not necessarily a interrupting issue, but let's just try to make sure we don't talk over each other for record purposes.
Yes, Your Honor. You worked with Karen, though.
I don't know that.
She worked at Wild Wildlife and you worked at Wild Wildlife.
I know that I worked at Wild Wildlife.
And you also worked with your father, who was working with Karen.
I worked with my father, yes.
And the three of you did work together for several years.
I don't know that.
You know that your feelings for Karen were never a secret to your father.
I have no knowledge on that subject.
Well, you know that your father, or you had told your father, expressed to him that you did not like Karen.
I don't know that.
But he stayed with her anyway.
I worked for my father.
Let me back up so that you might understand me a little bit better. You were close to your father.
I was.
You and your father talked.
Yes.
So you'd express things to your father.
I'm sure I did.
He knew that you did not like Karen.
Objection, Your Honor. Asked and answered to this very specific question.
Overruled.
On, Your Honor. It's fine. I've just got a few more questions for you, Ms. Donaldson. Your father's last will, it leaves everything to Karen.
The fake will does.
You don't believe, like you just mentioned, that he signed that will.
No, I do not.
You don't believe he would give everything to Karen.
No, I don't.
You don't believe he would choose to leave you nothing.
That's correct.
Well, you enjoyed spending time with your dad.
I did.
You saw each other at Sunday dinners.
Yes.
You saw each other at work.
Yes.
Sunday dinners were hosted at his house.
Yes.
where Karen also lived?
I assume so.
And so the Emporium was where you guys could spend some alone time.
I'm sorry, that didn't come through clearly.
I'll ask you again. The Emporium was where you and your father could spend some alone time.
I have no knowledge on that subject.
You don't know if you saw your father at work?
We did. I don't know if we were alone.
But then Karen started coming around the Emporium.
I have no knowledge on that subject.
Well, your time with your dad did have to be shared with Karen.
I don't know that.
You don't know that he spent time with his wife?
No.
He did choose then to spend some time with Karen instead of with you.
I don't know that.
Okay, let's talk about some things that you do know. You wanted to take over Wild Wildlife for your dad.
I do now. I was his assistant before.
Right, he did keep you on as his assistant
Yes.
while he made Karen his co-owner.
I have no knowledge on that subject.
And he chose to make her his co-owner instead of choosing you as his co-owner.
I have no knowledge on that subject.
That's all right. With everything that we know today, you don't believe that your father would choose Karen over you this time?
I don't think my father had a choice this time because Karen killed him.
You don't think that your father would not leave anything to you?
No, because I knew about his actual will and it left something to me.
But it didn't leave you everything.
No, it didn't.
And that's what you're asking for today.
It is.
No further questions, Your Honor.
Thank you. Redirect.
Yes, Your Honor, brief redirect. Just one moment. Ms. Donaldson, on cross-examination, a defense counsel asked you about what you thought that your father was going to leave to you. Now, in regards to that, what do you know?
I know that my father's real will, the one that was kept in a lockbox, the lockbox that Karen took, left 25% of his estate to me, 25% to my mom, 25% to create a foundation for Wild Wildlife, and then 25% to Karen Beja.
Defense counsel asked you quite a bit of questions on what you didn't know about your father and maybe his marriage. What do you know about anything that your father ever filed against the defendant?
So my father filed a temporary restraining order against Karen Beja.
Do you know why your father filed that temporary restraining order?
Because he was afraid of her.
Objection, Your Honor, lack of personal knowledge.
As to the temporary restraining order or the fearful?
Is to lose reason for filing that.
Okay, response to that objection?
Lack of personal knowledge, Your Honor. This witness has personal knowledge as to the reason, and if she has, if she knows, she can answer.
Yeah, I guess I'm not sure how you're going to lay the foundation that this witness knows why he filed a temporary restraining order. I think you can argue why someone might file for a temporary restraining order in closing. I'll give you a chance to try to lay the foundation. So I'm going to sustain the objection. If you can lay more foundation, I'll allow it.
Yes, Your Honor. Ms. Donaldson, you mentioned a filing from your father. Were you aware about the circumstances for that filing?
Objection, Your Honor, to the same thing, lack of personal knowledge. This is getting to why Mr. Donaldson filed, and she does not have personal knowledge of this.
I think she's trying to lay the foundation. So I think your objection is understood, but I think it's just a touch premature. Based on what this witness says, you might be able to renew your objection.
I'll go ahead and repeat my question, Ms. Donaldson. Were you aware of the circumstances surrounding why your father filed the temporary restraining order?
I know that, he wanted a divorce, and he and Karen were fighting. And I believe he was afraid.
Objection, Your Honor. Her opinion, her belief is not relevant, and it's not based on any factual knowledge.
I agree. I'm going to sustain the objection.
Yes, Your Honor. Donaldson, why do you believe that you deserve the deed to wild wildlife?
Because,
Your Honor, it's not relevant why she believes she deserves anything.
Oh, I think it is. I mean, she's asking for damages, so why she believes those damages are relevant and that she should be awarded them. So I'll allow it.
Ms. Donaldson, why do you believe that you deserve the deed to wild wildlife?
because that's what my dad would have wanted. He would have wanted me to take care of the cats. He wouldn't want the person who killed him to have his business.
Now, would this honor your father by doing that?
Yes, I believe it would.
No further questions, Your Honor. May this witness be dismissed?
You may. Thank you, Ms. Donaldson. Plaintiff, you can call your next witness.
Brief moment, Your Honor, and my co-counsel will be in here shortly.
Your Honor, plaintiff calls Taylor Pride.
All right. Ms. Pride,
Yes.
whenever you're ready.
Hello, Taylor Pride. I know we've had the pleasure of meeting before, but could you please introduce yourself to the members of the jury?
Yes, my name is Taylor Pride. I am a private investigator and a forensic document examiner. I have been a private investigator since 2016.
Now, prior to becoming a private investigator, what did you do?
I had worked with the Pioneer Police Department for about 18 years, where I was a patrol officer, and about 2 years into the job, I got promoted to detective.
So during your time as detective, what sorts of cases did you investigate?
Every type of case, from economic crime all the way to murder. And I was actually put on the economic crime unit for about 6 years, where I investigated forgeries heavily.
So you mentioned that you investigated forgeries. Was there any training that you had to receive in order to do that?
Yes, I had to do an extensive 2-week seminar where I learned to compare and analyze handwriting. And that was hosted by the American Association of Handwriting Analysts, which is a premier organization for analyzing handwriting and document examination.
Have you been certified in this field?
Yes, I am certified by the American Board for Forensic Document Examination.
Have you testified prior to this trial as a witness?
Yes, I have testified approximately 15 times prior to this as an expert in handwriting analysis and document examination in both civil and criminal cases.
Now, how did you become involved in this case?
I was hired on to investigate the disappearance of Lou Donaldson, as well as analyze the document that has been presented as the last will and testament.
Have you formed an opinion in that regard?
Yes, I have formed a 2-part opinion.
What did you review in order to form that 2-part opinion?
In order to form this opinion, I have looked at the last will and testament, the court document or the restraining order. I have also looked at the financial records of Lou Donaldson. And lastly, I reviewed Chris Renard's report.
You've told us about some documents you reviewed. Was there anyone you spoke with in order to form this opinion?
Yes, I had also spoken to Miss Samantha Lane, who is an alleged witness on the will.
Now, were these documents you reviewed and this conversation you had sufficient for you to form your opinion?
Yes.
And will your opinion be helpful to the jury in understanding the facts of this case and issue?
Yes.
Your Honor, plaintiff offers Taylor Pride as an expert investigator with a specialty in forensic document examination.
Sorry, you cut out just a little bit. What's the tender?
The tender is as an expert in private investigations with a specialty in forensic document examination.
All right, any objection or voir dire?
No objection or voir dire, Your Honor.
All right, this witness shall be tendered as an expert in, what is it? Private investigation and specialty in forensic document analysis.
Yes, Your Honor.
Okay.
Now, Investigator Pride, you mentioned that you formed a two-part opinion. What is the first part of that opinion?
So the first part of my opinion is that the last will and testament is fraudulent.
And how did you make that determination that this last will is fraudulent?
Because the signature on this will is a forgery.
How did you determine that this signature is a forgery?
I went through a 3-step process in which I compared the known signatures of Lou Donaldson to the signature on this will.
So you just mentioned known signatures that you used. What were those known signatures?
I had used one coming from his driver's license and the other came from the court document.
The court document, can you be more specific about the court document you were referring to?
Yes, this was the temporary restraining order.
Referring opposing counsel to what's been bait stamped as 007 and 0016. Investigator Pride, do you have these documents before you?
Yes, I do.
I'd like to start with what's been bait stamped as 007. What is this?
This is a document representing the signature comparison.
And how do you recognize this document?
This is a part of Chris Renard's report in which I reviewed during my investigation.
Is it in the same or substantially the same condition as the last time you reviewed it?
Yes, it is.
I'd like to turn your attention now to what's been bait stamped as 0016. What is this document?
This is the temporary restraining order, and it contains Lou Donaldson's signature.
And how do you recognize it to be a temporary restraining order with Lou's signature on it?
This is also something that I had reviewed during my investigation.
Is it in the same or substantially the same condition as the last time that you reviewed it?
Yes, it is.
Your Honor, at this time, plaintiff offers what's been bait stamped as 007 and 0016 as plaintiff's exhibits 4 and 5 respectfully.
Any objection to 4 and 5?
No objection, Your Honor.
Okay. 4 and 5 shall be admitted in their entirety.
Yes, Your Honor. May we publish the exhibits?
You may.
Investigator Pride, I'd like to focus in on exhibit 4 here on the left. Can you please tell the members of the jury what the signature in the middle is?
Yes, so the signature in the middle comes from Lou Donaldson's driver's license.
Now, what are the other two signatures on this exhibit?
These are the other signatures that Chris Renard has obtained, the first of which comes from the insurance, the life insurance policy, and the last is from the will in which we both reviewed.
Now, I'd like to focus your attention on the document to the right, exhibit 5. Please tell the members of the jury what this exhibit is.
This again is the temporary restraining order, which contains Lou Donaldson's signature.
Now, you mentioned that you used 2 known samples. What did you do with those 2 known samples?
I had looked at both of them and came to the conclusion that these came from the same person.
And when you made that determination that they came from the same person, what did you do next?
I had used these and compared them to the signature on the will.
Now, I'd like to focus in on these 3 signatures side by side, the 2 known samples you used and the signature on the will. Your Honor, may we publish along with these 2 exhibits what's been admitted as plaintiff's exhibit 5?
You may. If it's already been admitted and it's already been published, you don't need to ask my permission.
Yes, Your Honor. Now, Investigator Pride, could you please remind the jury of where these 3 signatures come from?
Yes, so the one on top comes from the driver's license, the second from the temporary restraining order, and the last comes from the last will and testament.
So you mentioned that you compared the two known samples to the signature on the will. What did you see when you made that comparison?
So there were three major things that were pointed out to me. The first were the pen strokes. The second were the lazy letters, and in this case, the lazy O, and lastly, the quivering.
So you mentioned pen strokes. Can you please explain to the members of the jury what you mean by pen strokes as it pertains to these signatures?
Yes, so if you look at these top two signatures, you can see that there was one single pen stroke where the capital D is in Donaldson from beginning to end. And the signature from the will demonstrates multiple pen strokes, and that also suggests that the pen was lifted on multiple occasions.
So you've told us about pen strokes. You also mentioned just a moment ago lazy letters. Can you please explain to the members of the jury what you mean by a lazy letter?
Of course. So a lazy letter is typically a letter that is not written very clearly towards the end of a signature. In this case, we look at the second O in Donaldson. The driver's license and temporary restraining order very clearly show very lazy letters, whereas the will shows very clear letters. Whoever had signed this wrote very clearly.
So we've talked about pen strokes. We've talked about lazy letters. You also mentioned quivering lines. Can you please expand on what you mean by a quivering line?
Yeah, so a quivering line indicates to me that the writer is very nervous and writing very slowly. And when a forger writes, they typically write slowly because they're attempting to copy an already known signature.
So we've discussed these signatures. I'd like to turn to Plaintiff's Exhibit 1 now and discuss the contents of that will. Can we stop sharing screen at this time? Now. Waiting for Plaintiff's Exhibit 1 to be shared on the screen. I apologize, Your Honor. I'm working with the tech throughout this competition, and we're waiting for the
That's
exhibit.
okay. No problem.
Yes, Your Honor. It appears we may not have Plaintiff's Exhibit 1, but I can go ahead and ask the questions about Plaintiff's Exhibit 1. Investigator Pride, do you have Plaintiff's Exhibit 1 before you? Oh,
yes, I do.
That's on the screen. Let's see. Perfect. Investigator Pride, do you see Plaintiff's Exhibit 1 on the screen?
Yes, I do.
Can you please read for the members of the jury the first sentence of the second paragraph up until the comma?
Yes, it says, I appoint Karen Beja to be the sole executor of this will, and if I should die or disappear.
Now, what does this portion of the will indicate to you?
This had helped me further conclude that this will is fraudulent. In my years of experience in looking at hundreds of forged wills, I have never really ever seen the word disappear.
Now, I want to turn to the signatures of the witnesses on this will. Who are the witnesses listed here on this will?
One of them is the beneficiary, who is the defendant, Miss Beja, and the other comes from Miss Samantha Lane.
Now, without telling the jury anything about Miss Samantha Lane, you mentioned earlier that you spoke with her. Did you rely on what she told you during that conversation?
Yeah.
Was it helpful in forming your opinion in this case?
Yes.
Your Honor, at this time, I would like to take up a motion in limine regarding information that was obtained from Samantha Lane. If I recall correctly, you reserved ruling on this matter pursuant to foundation being laid. I believe, Your Honor, at this time, we have laid a proper foundation that this witness has knowledge of the statements that were made by Samantha Lane. And we would like to go into those statements at this time.
All right, Ms. Dugan, what's your position now?
My position is still that there is going to be a lack of foundation here. It's also hearsay. My hearsay argument is, yes, experts can rely on hearsay. 703, however, is not a backdoor to get otherwise inadmissible evidence in. Evidence would have to be more probative than it is prejudicial. anything that Samantha Lane said or did is going to be more prejudicial for the jury to hear today. We are not allowed to cross-examine Samantha Lane. She won't be present in court today. The jury is not going to get a chance to decide if she's truthful or not.
Yeah, I do have some concerns that this is going down a little bit of a rabbit hole, because then we're going to get into this debate about whether or not she was under duress or influenced to, or scared or threatened or whatever. So I do have some concerns about that. What's the extent of the questioning you're going to go into with this?
Your Honor, I will be asking this witness about information that she learned from Samantha Lane during a phone call in which she states that, may we be heard outside the presence of the jury? May I assume we are?
Yes, and our housekeeping matter said we're always constructively outside, so we can just assume that when we go into substantive matters, the jury's gone.
Yes, Your Honor. So we will be going into these statements to prove that as this expert has opined and has mentioned throughout this trial, that this will is fraudulent. And hearing these statements from Ms. Lane furthers that argument that it is, and it will allow the jury to assess this opinion and to assess for themselves whether this in fact is a fake will.
I'm going to sustain the objection for now with this witness. I certainly think that I'm willing to entertain this on cross-examination of Mr. Renard. I think it's certainly more relevant there because that would go to his credibility. But I have some concerns with going into it now. I really do have concerns about the hearsay issue. And I think your witness has testified sufficiently, about her thought process on whether or not this was forged. So I'm going to sustain the objection. That does not preclude cross-examination. We can renew this piece for cross of the expert.
Yes, Your Honor. Now, we may stop sharing screen at this time. Investigator Pride, you mentioned you formed a two-part opinion and you've told us about the first part. Please tell the members of the jury what the second part of this opinion is.
Yes, so the second part of my opinion is that the defendant, Ms. Karen Beja, is responsible for the death of Lou Donaldson.
And how did you determine that Karen Beja was responsible for the death of Lou Donaldson?
During my investigation, I had also looked at financial records in which I had determined that prior to his disappearance, there was no activity in the bank account.
What was the amount of money that was left in that account?
It was about $100,000, I believe $98,000.
You told us about financial records that you reviewed. What else led you to conclude that it was the defendant who was responsible for Mr. Lou Donaldson's death?
Mr. Lou Donaldson had told the defendant, Ms. Karen Beja, that he wanted a divorce.
Pass the witness, Your Honor.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Pride.
Sorry, one second. You guys might see me standing for a second. I'm literally like 9.5 months pregnant right now, so I might just have to stand for a second. Ignore me.
Okay, we can do that. Good evening, Ms. Pride.
Good evening.
Ms. Pride, you have an extensive history in investigations.
Correct.
And you worked in law enforcement.
Correct.
For 16 years.
Correct. 18 years at the police department.
Right. And in those years, you received reports from people alleging bad facts.
I would assume so.
So you had to investigate.
Correct.
And in your experience, you know that sometimes people tell the truth.
Correct.
Sometimes people don't tell the truth.
Correct.
And in this case, you reviewed some documents.
Yes.
And one of those things that you relied on was the restraining order.
That is correct.
That had statements from Lou.
Correct.
Statements about death threats.
Correct.
And those statements could be true.
Correct.
Those statements could also not be true.
Correct.
And the court denied that request.
Correct.
And you didn't interview Karen about it.
No, I did not.
And you didn't investigate those allegations any further.
No, I did not.
And you're here today for the plaintiff, Cam Donaldson, correct?
Correct.
And you did interview Cam Donaldson about this case.
No, I did not.
Well, Cam hired you, correct?
Correct.
But you didn't talk to Cam at all?
Not to my knowledge.
I'm sorry. You were hired by Cam, and Cam said 0 words to you about this case. He just said, "You're hired, here's money."
Well, obviously there had to be some type of conversation during the hiring process.
Right, so you did talk to Cam.
Correct.
And he's the person who's paying you to be here today.
Correct.
The person, if believed, stands to gain millions.
Correct.
In your investigations, one of those things that you analyzed were the handwriting samples, correct?
Yes.
Something you've been doing for many years.
Yep,
In fact, you're certified to analyze handwriting samples.
I am.
You've done a lot of them and written a lot of reports.
Correct.
And you know it's important to be thorough,
Yes.
to use the best tools available.
Yes.
And you know it's important to use original signatures
Correct.
because you know originals are best.
Correct.
And in this case, you analyzed Lou's signature on his will.
I analyzed the signatures on his driver's license and the restraining order alongside the signature that was presented on the will.
Correct. And you were doing that to determine if that signature was in fact Lou's.
Correct, which I concluded that it was not.
And you compared his signature to his driver's license as well.
Yes.
Not the original he signed at the time he got his license, though.
I don't know.
Well, it would have been a copy.
I'm not sure.
Well, I'm sorry, you're an expert in this case, correct?
Yep.
And as an expert, you would know if something was an original or a copy, correct?
In terms of the signatures, yes, because I'm a handwriting analyzer, sorry.
Right. And so when you were analyzing this case, you would have known if his driver's license was an original or a copy.
Correct.
Okay, and you compared that signature to the restraining order.
Correct.
Not the original in the court file.
I assume so.
Right, but a copy.
Sure.
So you used 2 copies.
Yes, of
Not
one. Correct. Go ahead.
And you did have a letter from Lou.
Can you specify what you mean by that?
Yeah, you had a letter from Lou to his children, correct?
Yes, I did.
And that letter was an original,
Yeah, it was.
not a copy.
Nope,
Meaning that you had an original of Lou's signature for your investigation.
I did.
But nowhere in your report did you share an analysis of that signature.
No, I didn't analyze that signature because I came to my conclusion with just the 2 documents that we've discussed.
Right, so you chose to use copies in your analysis,
Correct.
even though originals are best.
Correct, but those are original signatures.
Are those are not considered original signatures according to your...
Sorry, there was a connection issue. Can you repeat the question?
Right, those were not original signatures according to your own standards, correct?
Correct, there was a copy of the driver's license, but the signature was true of Lou Donaldson.
Right, that was your conclusion, but it was a copy.
Correct.
So, Ms. Pride, in your experience as an investigator, you know what's important when investigating a document, that it's important to verify its authenticity.
Correct.
And you would talk to any witnesses of the document.
Sure, yeah.
Well, you need to get a full understanding of what you're investigating.
Uh-huh.
Because you have to leave no stone left unturned.
Correct.
To come to a valid conclusion.
Yes.
And another one of those suspicious circumstances in your report was a lockbox.
I have no knowledge on that.
Well, your report reflects that you have knowledge of Cam getting a lockbox. Are you testifying today that you have no knowledge of that?
No, I don't remember.
So you wrote a report today and you were prepared to testify in trial today, correct?
Yes.
And you don't remember what's on your own report?
I'm just forgetting that specific detail.
Okay, and so one of those, so in this supposed lockbox, there was another will. You can agree that we've talked about another will today, and so does your report.
Yes.
And you found that suspicious.
Correct.
And you heard there were 4 other beneficiaries on it, correct?
I heard that in court today, correct? Yeah.
Right, so we had Karen,
Correct.
Lou's ex-wife,
Correct.
Cam,
Correct.
and a foundation for the wildlife sanctuary.
Correct.
But you didn't interview Karen about that other supposed will.
No, I did not.
And you never saw another will.
No, I did not.
And when investigating, it's important to have all the documents reasonably available to you, correct?
Yes, but again, I was able to make my conclusion with the documents that I did use.
Right, and you do this so you can get a whole picture.
Correct.
So you can reach the right conclusions.
Correct.
And when you're investigating, you want to know what happened before, during, and after.
Correct.
Because sometimes knowing what happened before can give insight to why things happen or don't happen later.
Sure.
And another suspicious circumstance that you did on direct were Lou's financial records.
Correct.
Records from August 1st to September 15th, 2017.
Correct.
And Lou went missing around August 18th or 19th, correct?
August 18th of 2012, yes.
And so you checked his withdrawals in August.
Correct.
But you didn't check his withdrawals in July.
I had I checked the bank statement.
Correct, you checked the bank statement from August.
Correct.
But you didn't check the bank statement from July.
No.
And you didn't check the bank statement from June.
No.
So you wouldn't know if Lou took out a large sum of cash before August.
I don't know.
And you don't know if Lou transferred money before August.
I don't know.
And Ms. Pride, when analyzing an investigation done by another agency, it's important to know their methods and tactics, correct?
Another what? Sorry?
To know their methods and tactics.
Sure.
You want to know who they talked to,
Sure.
where they went.
Sure.
It's a way to gather all the facts about a case,
Okay. Correct.
which you need to do.
Yes.
Because without all the facts, you might miss something.
Correct.
Because you wouldn't want to come to a hard, definite conclusion without them.
I can still form conclusions, but based on what you're saying, sure.
So you concluded that the police department didn't investigate thorough enough
Correct.
because they didn't find a body.
Correct.
But you didn't find a body,
No, I did not.
and you never saw the police reports.
No, I did not.
So you don't know their investigation methods,
No.
and you never interviewed the police involved.
No, I did not.
So you found it suspicious, but you didn't investigate.
No, I did not.
Thank you. No further questions.
All right, thank you. Redirect.
Yes, Your Honor. Investigator Pride, on cross just a moment ago, you were asked about some bank statements. What was the final date? What was the date of the final transaction on that bank statement you reviewed?
I believe it was August 17th of 2012.
When was the last day that Lou Donaldson was seen alive?
August 18th of 2012.
Now, you were also asked about signatures that you reviewed. Were the signatures that you reviewed sufficient enough to form your opinion?
Yes, it was sufficient enough to form my conclusion.
No further questions, Your Honor. May this witness be excused?
Yes, she may. Thank you.
Yes, Your Honor.
Are there any additional witnesses from the plaintiff at this time?
Yes, Your Honor. At this moment, may we have an opportunity to switch out with the advocate?
You may.
Thank you, Your Honor.
Your Honor, at this time, plaintiff would like to essentially play a video which has been declared unavailable witness testimony from an exotic Bob. That's it.
Sorry, I'm on mute. It's my understanding by stipulation, exotic Bob is declared unavailable. Is there any issue with playing the video from the defense perspective?
Yes, Your Honor. This is hearsay. There is no exception for the hearsay in this video.
Is this not by stipulation that exotic Bob is declared an unavailable witness?
Your Honor, I respond and maybe answer your question at the same time.
Sure.
So Your Honor, the witness is stipulated to being unavailable under Federal Rule of Evidence 804A, which is just the criteria that some witness will have to meet to be unavailable. However, under 804B, the witness has to also meet an exception for that testimony to be admissible hearsay. And there are actually two levels of hearsay within this testimony. The first being from the witness himself, exotic Bob, as this is an out-of-court statement that we're offering in court today. And we mentioned 804A that he is being stipulated as to being unavailable. Under 804B, both 804B3 and 804B6 would account for an exception for this witness. 804B3 is a statement against interest. You will hear the testimony if it is admitted that exotic Bob is essentially going to admit his role and make himself culpable in this illegal scheme that he had with the defendant. Furthermore, under 804B6, that is a statement against a party, offered against a party who has wrongfully caused the declarant's unavailability. You will also hear that exotic Bob thanks Karen Beja for the reason why he is in federal prison at this time. Furthermore, the second level of hearsay is statements made by Karen Beja to exotic Bob, and these are not hearsay because they're statements by a party opponent.
Okay, Ms. Dugan, what's your position on that?
As for whether or not Karen wrongfully caused exotic Bob to be in prison, there's no proof of that. So we don't know why exotic Bob is in prison, and his conclusions mean nothing to us. In addition, these statements are entirely more prejudicial than they are probative because they are not relevant to the case at hand today. What exotic Bob has said in those video statements has absolutely nothing to do with Lou Donaldson, with Karen Beja, with Cam Donaldson. They're completely out of the realm of this court today. And I'm sorry, I didn't respond to the statement against interest.
And that's what I'm most, just to direct everyone, I agree with you that the argument that he's unavailable because she wrongfully caused, I don't agree with that. So I do think that these might fall within statement against interest. So why don't you respond to that piece? That's what I'm most interested in.
Right. Well, at the current time, exotic Bob is in prison, and the standard is a reasonable person, whether or not a reasonable person would say these statements. I don't think exotic Bob would understand the conclusions that would come from these statements that he's made. I don't think a reasonable person would understand what these conclusions are made. And the statements that he's making against interest don't have anything to do with what we're talking about at trial today. This is a completely different scheme, only meant to inflame the jury against Karen Beja.
All right, thank you. I understand the argument. I'm going to admit exotic Bob's statement, and you may play it.
Yes.
And for the defense, if there's any pieces of this that you would wish to play for the rule of completeness sake, you can certainly do that after they present, just kind of like a direct and cross.
Thank you, Your Honor.
Your Honor, we will play this video now by using share screen for the jury.
Sister, where you put your mister? Lion's den. Hey, that sister, where? See them to the lion's den. I'm Exotic Bob. You probably recognize me as the owner of the world-famous leopard tent, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system, compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we never worked together before, we never worked together since. But due to the severe illegality of the deal, we thought it best to be work together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped suddenly, turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband."
Your Honor, objection. Hearsay.
It's no mythical flight to Costa Rica. She was your last supper.
Can we pause the recording so we can address the hearsay? All right. You were objecting to what Ms. Baja was saying?
Yes, I'm objecting to what Mr. Exotic Bob said, Ms. Baja said.
Okay, response, Ms. Samant?
May I just have the grounds for the objection, Your Honor?
I believe it's hearsay.
Your Honor, as previously stated, this is a statement by a party opponent under 801D. This is not hearsay. It is exempted from hearsay.
Ms. Dugan?
Your Honor, this is more prejudicial than it is probative.
I disagree. We'll certainly let the jury decide, but let's continue playing. I'll overrule the objection.
Will be you. I'll feed you to my kiddies just like I did him. And then she turned around and she walked out of my office. That's all I've got to say about that. Where you think you're going? We don't know where you've been. Hey, where you think you're going? We don't know where you've been.
Go ahead and stop sharing. Thank you, Mr. Calderola. Your Honor, this completes the plaintiff's witnesses and we rest.
All right. We're going to take a brief break, but before we do that, are there any motions that the court should consider at this time?
Yes, Your Honor. At this time, the defense does move for a judgment as a matter of law, as the plaintiff has not met their burden to make a submissible case. In order to make a submissible case, they must prove that a reasonable juror could find that Lou is dead, that he died because of Karen's intentional or reckless conduct, that Cam suffered injuries, damages, or losses as a result of a death, and that Karen's conduct, intentional or reckless, did cause Cam those injuries. They have not produced any physical evidence that Lou Donaldson is in fact actually dead, only that he has been legally declared dead, which is, it's a legal remedy. It is not proof of anything. Further, the plaintiff has not proven that Karen Baja is responsible for Mr. Donaldson's death, if he is even dead. Therefore, we are requesting the court grant a judgment as a matter of law.
Your Honor, my counsel is going to go ahead and respond to this motion. We'll be switching out at this moment.
Okay.
Your Honor, for a judgment as a matter of law, the evidence must be viewed in the light most favorable to the non-moving party. Here, that is the plaintiff. Your Honor, we have presented substantial evidence in the form of testimony and documents that establish that Lou Donaldson is dead. He has not been seen since 2012. His bank accounts have been untouched. And we have established that the defendant has a clear motive for causing Mr. Lou's death. There is evidence that was presented by an investigator and a forensic document examiner who is an expert in these fields, and she has testified that these documents that were presented by the defendant are forged, they're fake, and that she has had a TRO filed against her by the defendant herself. For that reason, we would respectfully ask that this motion be denied today, Your Honor.
All right, thank you. When viewing the evidence in the light most favorable to the plaintiff, I'm going to deny the halftime motion and we will proceed after a 10-minute break with the defense case in chief. Prior to doing so, though, are the timekeepers ready to give me a time check, or do you need some time? You can certainly give it to me when you wait. We've got an answer. All right, plaintiff has used 42:55. Defense has used 33:14. If I recall correctly, each side has 70 minutes. Does that sound right to everyone? 42:55 plaintiff, 33:14 defense?
Yes, Your Honor.
All right, let's come back right around 8:17-ish. You can turn your video and mute off. We'll see you back here soon. All right, are the parties ready to proceed with the defense case in chief?
Yes, Your Honor.
Yes, Your Honor.
Okay, great. Who are we calling for the defense first witness?
The defense will call Ms. Karen Baja.
All right, Ms. Baja.
Your Honor. May we have 1 second to switch advocates, as the other advocate will be handling cross of Ms. Karen Baja?
Yes, that's fine.
Yes, Your Honor.
Apologies, Your Honor.
All right, whenever you're ready.
Thank you, Your Honor. Good evening, Ms. Baja. Can you please tell us your name?
My name is Karen Baja.
And what do you do for a living, Ms. Baja?
I work at the Wild Wildlife Sanctuary. I actually own it. It's my life's work.
And tell us about the Wild Wildlife Sanctuary.
It's a wildcat sanctuary. We call it a tiger and a big cat emporium. We take care of big cats every day, feeding them, bathing them. I love those big cats.
And what do you do there?
My favorite part is caring for the cats, but now that I'm the sole owner, I have to do most everything. It's absolutely my passion to care for those animals.
And what kind of big cats do you take care of?
Big cats, lions, tigers, leopards. One of my babies is named Tara. I love her so much. I spend my days taking care of cats just like her. They're my furry family.
And how long have you worked at the Wild Wildlife Sanctuary?
Ever since my husband and I got married in 2001, we've owned it together ever since.
Well, let's tell the jury about your husband. Who was your husband?
Lou Donaldson.
And how long were you two married?
We got married on May 29th, 2001. So we were married 11 years before he disappeared.
And how did you two meet?
I was hitchhiking one night. I come from humble beginnings, basically living poor most of my life. Lou saw me and picked me up off of the side of the road.
And what made you feel safe to get in a car with him?
He looked nice, and he ended up being my knight in shining armor, even though he was driving this old van.
And we heard today that Lou was a millionaire and he picked you up in a beat up old van?
Yeah, that was my Lou. He was just eccentric. Not a lot of the things he did make sense.
What did you do after he picked you up?
We stayed together all night. Lou was very spontaneous. We immediately fell in love and ended up getting married. Love at first sight, you could say.
And what were the rest of your 11 years like?
Things were good. We had a lot of good years together, and of course, taking care of all the animals.
And did Lou always work at the sanctuary?
No, he used to actually be a used car salesman, but ever since we were married, we worked at the sanctuary together.
Were you two happy?
Oh, yes. I mean, we had our ups and downs, of course. Any relationship does. We were together for so long, but it was definitely happy overall. Well, at least up until the day he vanished. Up until then, we lived together and worked on our marriage.
You mentioned Lou was spontaneous. What other spontaneous things would Lou do?
Well, he had some planes, and he would often just fly out whenever he wanted.
And how did that spontaneity affect you?
I didn't really mind it at first because I was a part of it. It didn't really start hurting me until I found out there was a mistress in Costa Rica that he would fly down to go see.
Did you ever meet this mistress?
Oh, no, of course not.
How did it make you feel that Lou had a mistress?
It felt absolutely horrible, but I was willing to work things out with him. I loved him.
Let's tell the jury about your marriage. Would you say your marriage is perfect?
No, I wouldn't. I wouldn't say anyone's marriage is perfect.
And why not?
I mean, we had our disagreements every once in a while, like most couples do.
Well, what kind of disagreements?
Well, Lou did ask me for a divorce because of the mistress, and that hurt.
Miss Baja, we saw a restraining order today. Did you threaten to kill Lou?
No, I would never. I loved Lou.
Did you ever do anything to cause Lou to feel unsafe?
Absolutely not. Like I said, I loved him.
Did Lou file for divorce?
Not that I was ever made aware of.
And was that restraining order granted?
No, the court denied it. He didn't need it. I didn't threaten him. I loved him and I would never hurt him.
And where did Lou live after he requested the restraining order?
With me, we still live together.
And what happened after that?
We continued living together and we're trying to make things work.
You mentioned earlier that Lou liked to fly. How often did Lou fly?
I didn't really keep track of how often he would fly because he would just leave sometimes. So he could be offline or really doing anything. He was quite spontaneous.
Well, would Lou tell you when he was flying?
No, not always. Sometimes he would even leave without a flight plan and without telling anyone.
Well, would you know where he was going?
Not really, not all the time. I mean, I knew he went to Costa Rica sometimes since I knew he had a mistress down there. For all I know, that's where he is right now.
If you believe he's there now, have you told anyone this?
I told the police, but Lou didn't even have his flying license and he wouldn't record a flight plan because of that. So it's not exactly easy to track.
Thank you. And Ms. Baja, let's briefly talk about a video that we saw earlier today. Who was on that video?
Exotic Bob.
And how do you know Exotic Bob?
I took his kittens, his big tiger kittens, and it was my civil case that put him in prison. He was found liable.
And were those statements that Exotic Bob said true?
No.
Why do you believe that?
He hates me and has a notice out. He wants to lie about me for revenge. He's just mad that he broke the law and I came after him for it because I love these cats so much and I want to make sure they're safe. And he was not taking care of his cats properly.
Well, Ms. Baja, let's tell the court who the plaintiff is today. Who is Cam Donaldson?
Cam is Lou's daughter. We used to work together at the Wild Wildlife Sanctuary until I had to let her go.
And why did you let her go?
Well, she hates me. I knew we couldn't work together, so I had to let her go.
Why?
I mean, many reasons. I married her dad and she didn't like me from the beginning. Her family before always thought I was just out for Lou for his money. She was always suspicious of me right from the beginning. It never got better.
Were you out for Lou because of his money?
No, how would I even had known that he had money? He picked me up in this beat up old van off the side of the road.
And what's your relationship with Cam like now?
I don't trust Cam. I know Cam wants answers for Lou, and I want them as desperately as she does. But Cam keeps creating these false conspiracies about me killing her father.
Have you and Cam worked together to find answers for Lou's disappearance?
No, she's never liked me and she never will, especially in light of Lou choosing me to continue his legacy with Wild Wildlife.
And why do you say that Lou chose you to continue his legacy with Wild Wildlife?
Well, his will left me all of his assets so I could continue taking care of our big cats.
Let's talk about Lou's assets. Ms. Baja, what were the assets that you inherited from Lou?
The insurance, that payout was $5 million, and the business itself is worth another $5 million.
And what plans do you have with those assets?
I plan on putting it all towards maintaining this home for my big cat family.
How did you receive those assets?
I had to have Lou legally declared dead after not hearing from him for so many years.
And so when did you do that?
5 years after he was missing. It was an incredibly hard decision.
Well, why did you declare Lou dead?
I needed the closure. It had been 5 years. As much as I didn't want to, I needed to move on. The business needed to move on. I lost my Lou. I couldn't also lose my big cats. I hoped and I prayed he would return home every day, but with each passing year, it became more apparent what the stark reality was. he was never coming home.
Do you know if Lou is actually dead?
He just disappeared.
Was Lou's body ever found?
No, not that I'm aware of.
We need to talk about the night that Lou vanished. August 18th. Will you run us through the events of that night?
Well, Tiger had given birth to cubs a couple of days earlier, and I was taking care of the cubs because the mother had rejected them. It was in the middle of the night when I realized I needed to go to the store to get supplies, milk, formula, stuff like that. I was so tired taking care of the cubs, I left the house without my cell phone, and after getting what I needed at the store, on my way home, my car broke down.
And about what time was that?
That was around 3 a.m. I didn't have my phone since I had left it at home in my rush, so I flagged down a car passing by to see if they could help, borrowed their phone, and then I called my brother because I knew he was working that night.
Well, why didn't you call Lou?
I never knew when Lou would be home. He could just leave at the drop of a hat. He was so spontaneous and secretive. I was focusing on our cats a lot at the time.
Well, then what happened after that?
Well, I went home after my brother picked me up and he dropped me off at home.
Okay, let's talk about the morning of August 19th now. You went to the office to grab a lockbox.
I did do that.
Why were you there?
I needed to get my things. I did not trust Cam.
But why then?
It was just different this time. With the mistress in Costa Rica and the fighting lately, the fact that he wrote disappearance into his will, it was different. I needed to go and get the important things.
What do you mean by different?
I felt like the writing was on the wall. Even though we were still living together, he had me sign a will talking about his disappearance. And that was just a month or so before that night.
Let's get into Lou's will. We're here discussing Lou's will. Did you sign that will?
I did.
What did you sign that will as?
A witness.
When did you sign his will?
June 14th, 2012.
Why was disappearance written in the will?
I don't know. Lou wrote it. Those are the words he chose to use. I just signed it. Lou didn't have a lot of logical explanations for why he did the things he did.
Karen, did you see Lou sign the will?
Yes, I did.
And did you kill Lou?
Absolutely not.
Karen, did you have anything to do with Lou's disappearance?
No, I loved Lou. I miss Lou. I wish he was still home.
Thank you. No further questions.
Thank you. Cross-examination.
May I proceed with cross? Ms. Beja, you made a few statements when on direct examination that I wanted to discuss with you. You said that you were the co-owner of Wild Wild Life. Is that correct?
Yes.
You also said that you fired Cam because you knew that you guys couldn't get along anymore and work together. Is that correct?
Yeah, she made it clear she hated me.
You also said that the reason you went to retrieve the lockbox is because you knew this time was different and you had to go there to get this lockbox for that reason. Is that correct?
Yeah, the writing was on the wall.
Ms. Beja, you remember giving a deposition in this case prior to coming to trial?
Yes.
In that deposition, you knew that you had to be complete,
Yes.
that you had to be accurate,
Yes.
and that you had to be truthful.
Yes, I did.
Ms. Beja, if you could locate a copy of your deposition at this time. Look at the last page there, and you'll see that there's a signature of authenticity.
Yes, I believe that there is a signature at the end of that deposition.
I'm going to direct you to the first page. It's about the fourth question and answer halfway through. You state, Lou and I dedicated our lives to the animals at Wild Wild Life. I'm going to go ahead and read it, and if you can follow along with me. That Lou and I dedicated our lives to the animals at Wild Wild Life, the Tiger and Big Cat Emporium. Nowhere in there do you state that you were the co-owner of Wild Wild Life. Is that correct?
Not in that deposition, no.
This is the first time that you are saying that you were the co-owner of Wild Wild Life in regards to this case.
No, I was the co-owner of Wild Wildlife.
Ms. Beja, you didn't say that previously, we established, is that correct?
I didn't say it in this interview here, but legally we were married and I was a co-owner as we owned the business together.
Ms. Beja, Mr. Donaldson started the business prior to your marriage.
And then we ran the business together as co-owners.
What points say that you were a co-owner? And that is my only question. Is that correct?
Yes, I was a co-owner.
Ms. Beja, can you point out where you list that you were a co-owner in this deposition?
I was married to Lou and we shared the assets.
That's not my question, Ms. Beja. Can you please point out in your deposition where you list you're a co-owner?
Well, if you want me to read the entire deposition, I can read it from beginning to end.
And nowhere from your reading of beginning to end will you find that you were a co-owner, because it's not in here. Is that correct?
If you say so, but I was a co-owner.
Ms. Beja, you also never mention why you fired Kim. If I can direct you to the second page of your deposition, about 3/4 of the way down, you state you don't trust Cam, and that's why you went to the office the night of Lou's disappearance. At no point do you say the reason I fired Cam is because we couldn't work together anymore in this setting. Is that correct?
Not in this interview, but that is the truth.
So it's not in there.
No, they didn't ask me about why.
And additionally, in the same statement, you don't say the reason for having to go retrieve the lock boxes because this time was different and you wanted to obtain documents for any personal reason. Is that correct?
Not in this interview, no, but that is the reason.
But it's not in this interview, Ms. Beja?
No, if you're asking if it's in that specific paragraph, then no. Like I said, I can read this from beginning to end for you if you wish.
Not necessary, Ms. Beja. I'll go ahead and move on with my questioning. You said on direct that your marriage was not perfect.
No, it wasn't, but no one's is.
I'm sorry?
No one's marriage is perfect.
Your marriage was so flawed that your husband wanted a divorce from you.
He did mention divorce, yes.
He also filed a temporary restraining order against you on June 12th, 2012.
He did, but it was denied.
It was denied, and the will that he sent, that you presented is dated June 14th, 2012. Is that correct?
Yes, that is correct.
Difference.
I'm sorry?
That's a 2-day difference.
Yes, it is.
Now, Ms. Beja, the night that your husband disappeared, you claimed to have gone to the store.
Yes.
You didn't have your cell phone with you.
No, I forgot it.
Your car broke down.
Yes, it did.
And then you called for help.
I did.
You called your brother.
Yeah.
He's a deputy sheriff in Pioneer.
Yeah, I knew he was on duty, so he could come and help.
So he picks you up.
Yes.
He takes you back to Wild Wildlife where those tiger cubs are.
Yes. Well, the tiger cubs were at home, not at Wild Wildlife.
So your brother's with you the night of the disappearance.
Yes.
Now, Ms. Beja, you mentioned that Lou went on trips all the time.
Yes.
Now, he didn't always record where he was going.
He didn't.
And for how long he was going to be gone.
No, but that was before all that had happened.
So all that had happened is that August 17th, 2012, you came home and Lou wasn't there.
No, I saw the writing on the wall considering he had been filing for divorce.
Ms. Beja, if you could just answer my question. You came home August 17th, 2000. Lou Donaldson was not there.
I didn't know if he was there, no.
This isn't the first time Lou hasn't been where you expected him to be.
That's true.
But you did file him a missing persons report this time.
I did.
You didn't mention filing any missing persons reports any previous times that he was gone.
No, I wasn't worried those times.
Now, you claim that you had him legally declared dead.
Yes.
You did this for closure.
I did it 5 years later.
In 5 years that you're mentioning, that's how long you had to wait to do this.
And I wanted him to come back. I was hoping they'd find him.
Ms. Beja, that's not my question. You waited 5 years to do this.
Yes, I was hoping he'd be found.
The 5-year period started from the time you reported him missing. Isn't that correct?
Yes. I mean, that's when they would have known.
Ms. Beja, you've previously been questioned by the police in regards to your husband's disappearance.
Yes.
They actually came to your property and they looked into a meat grinder.
Yeah, they didn't find anything though.
Referring the court and opposing counsel to what has been Bates identified as 0011, I'd also refer the witness to this exhibit. Ms. Beja, have you located the exhibit?
Yes, I have.
You recognize this photo?
I do.
You recognize it to be a meat grinder.
Yes.
And the reason you recognize it is because it is very similar to the type of meat grinder that would have been on the Wild Wildlife property.
Yeah, to feed the cats.
And it's a fair accurate representation of the type of meat grinder that you would have on your property.
Yes, for the cats.
Your Honor, at this time, plaintiff would offer into evidence what has been Bates marked as 0011 into evidence as plaintiff's exhibit 6.
All right, any objection to plaintiff 6?
Yes, Your Honor, I'm going to object to relevance.
All right, response to relevance.
Your Honor, in regards to the relevance, if we may be heard outside the presence of the jury, one of the essential elements of the plaintiff's case is to prove that Karen Beja's conduct caused the death of Lou Donaldson. In order for the jury to be able to properly analyze this element, they have to have all the evidence, specifically the means that the defendant would have had that the police looked into in order to facilitate the death of Lou Donaldson. Therefore, it is extremely relevant, and the bar for relevance is very low, Your Honor.
Okay, I will admit this exhibit, plaintiff 6.
May I publish to the jury, Your Honor?
You may.
Ms. Beja, you use a meat grinder just like the one on the screen here to grind up food for your cats.
Yes,
Now, you were questioned whether you ground up Lou Donaldson inside of this meat grinder.
and I didn't,
And you said you didn't, partly because it takes 2 people to use it.
but I didn't.
My question was, you said partly because it takes 2 people to use this meat grinder.
It does, and I also did not do it.
And the 2 people, the night of the disappearance, your brother was with you.
Yes, he picked me up from the store.
Ms. Beja, I'll stop sharing the exhibit at this time, Your Honor. Ms. Beja, when you married Lou Donaldson, you yourself said that you had very little.
That is true.
But today you sit here, the owner of a $5 million business.
But I'd rather have Lou.
That wasn't my question, Ms. Beja. If you could answer my question. Today you sit here, the owner of a $5 million business.
I do, but I would rather have Lou.
Your Honor, I would just move to strike the last part of that answer as non-responsive.
She's answered.
Your Honor, Ms. Beja, you sit here today, the owner of a $5 million business, and you have a $5 million life insurance policy.
Yes, unfortunately.
So you sit here today a millionaire.
Unfortunately.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Ms. Beja, are you the owner of Wild Wildlife Foundation?
Yes, and I actually did find a spot in my deposition where I did say that.
Can you tell us what exactly you said in your deposition then?
Yes, it's on page 2 in the paragraph about not being a huge fan of cams either, where I say I own wild wildlife. I had every right to be there.
Okay, thank you. My other question is, we talked about a meat grinder. Was there ever an investigation into the meat grinder?
The police did check the meat grinder, but there wasn't anything found.
And when you say there wasn't anything found, what do you mean?
I mean, they checked to see if there were human remains in the meat grinder because of this lie that Cam has been telling, but the police found nothing. It was clean because it's just used to feed tigers.
Thank you. May this witness be excused.
Yes, thank you. You may step down. Does the defense have any additional witnesses?
Yes, Your Honor. At this time, the defense calls Chris Renard.
All right, and Ms. Samant, you can switch out.
Thank you.
Just a moment.
And whenever you're ready.
Thank you, Your Honor. Good evening, Mr. Renard. Can you introduce yourself to the jury?
My name is Chris Renard.
Where do you live?
I live in Pioneer, Statesville.
What do you do in Pioneer, Mr. Renard?
I'm a claims investigator and a forensic document examiner for Summit Life Insurance Company.
Let's tell the jury about your experience. You said that you were a forensic document examiner. How long have you been doing that?
For 23 years now.
And where have you worked as an examiner?
I spent 3 years at the Statesville Bureau of Investigation Crime Lab, and I've been an examiner with Summit Life for the last 20 years.
Are you specialized in any forensic document examination fields?
I'm a specialist in handwriting and signature identification, as well as fabricated documents and altered records.
And are you a certified forensic document examiner?
I am. I have certifications from the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
Do you receive any training for this line of work, Mr. Renard?
I have, and I continually do. On an annual basis, I participate in training workshops and continuing education, all related to forensic document examination.
Well, you also said that you were a claims investigator. How long have you been doing that?
I've been a claims investigator for 20 years now at Summit Life the whole time.
And what are some of your duties in this line of work?
I conduct risk surveys to assess a loss. So I'll collect evidence and documentation. I'll conduct investigative interviews and review insurance claims, incidents, and police reports, all to verify claims.
Do experts in your field reasonably rely on those kinds of documents?
Yes.
Do you receive any training for this line of work as a claims investigator?
Yes, the annual training and education that I brought up earlier.
And have you had any other professional education?
Yes, a bachelor's degree in criminology from Summit College, and I also spent a year at the Statesville Police Academy.
Mr. Renard, have you ever testified as an expert in forensic document examination?
Yes, I have.
Have you ever testified as an expert in claims investigation?
Yes.
How many times?
I've testified as an expert a total of 25 times in both state and federal court.
And who have you given testimony for?
Mostly for Summit Life, but for the prosecution once.
Were you asked to review the facts in this case, Mr. Renard?
I was, yes.
And why were you asked to review these facts?
Summit Life Insurance wanted me to investigate whether or not we should contest the payment of Mr. Donaldson's life insurance claim to his wife, Karen Baja.
What did you review in performing that investigation?
I reviewed the interviews, photos, and depositions that were made available to everyone in the case. And I also reviewed some of Mr. Donaldson's signatures and his will.
Did you have the sufficient facts and data to form your opinion today?
Yes, I did.
Did you apply the principles and methods that are common in your field of practice?
Yes, as I always do.
And did you reliably apply the principles and methods to the facts of this case?
Of course, yes.
Your Honor, at this time, the defense tenders this witness as an expert in forensic document examination and claims investigation.
Any objection or voir dire?
Your Honor, we have no objection with the understanding that this witness will not get into any opinion regarding what may or may not have happened to Mr. Lou Donaldson.
Your Honor, if I may, this witness is an expert in claims investigation, and they, as an expert in claims investigation, do look at police reports, and hear from the police. So they do have the expertise to speak to any investigations. Further, it was part of Mr. Renard's charge to determine whether or not they should contest the payment to Miss Baja. Part of that was whether or not she was involved in Mr. Donaldson's disappearance. So it would be important for him to speak to that investigation and his conclusion.
I agree. Mr. Villarreal, what's your position on that?
My position, Your Honor, is that we have no objection to this witness testifying as to his determination about signing or approving this application on the will, but that does not necessarily require an opinion on what happened to Mr. Donaldson.
I disagree. I'm going to overrule the objection. This witness can certainly, I think with the tender of forensic document examination and claims investigator, I certainly think he can say whether or not he thought there was foul play or not. I guess I don't know exactly what this witness is going to say and how he's going to say it. So I certainly understand if he gets into just far-reaching sort of police work and police assumptions with like homicide commentary, then we might have an issue, but that's not my understanding of what this witness is going to say. So based on my knowledge of the case, I'm going to overrule your objection. Feel free to object to outside the scope, but from what I know about this witness, I don't think we're going to get there.
Yes, Your Honor.
Thank you, Your Honor. Mr. Renard, after you completed your investigation, what conclusion did you come to?
The first conclusion that I came to was that Summit Life didn't have the grounds to contest a payment based on Ms. Baja's alleged involvement in Mr. Donaldson's disappearance. The second conclusion I came to was that the signature on Mr. Donaldson's will was close enough to his known signature to warrant a finding that Mr. Donaldson did, in fact, sign the will in question.
And based off of that conclusion, what was your recommendation to Summit Life?
I recommended that we pay the proceeds of the life insurance policy to Mr. Donaldson's wife, Ms. Baja.
Let's explain to the jury your conclusion that Mr. Donaldson's signature on the will was in fact authentic. First, why were you investigating the signature on his will?
There was a question regarding the authenticity of the signature on the will, whether or not Mr. Donaldson was actually the person who signed it.
And how is the authenticity of the signature on that will important to your investigation?
Mr. Donaldson's will leaves everything to Ms. Baja. If the signature on the will was forged, it wouldn't be a legally binding document, and Ms. Baja wouldn't be entitled to the life insurance claim.
What is the procedure for examining a signature and deciding its authenticity?
I collect all the documents containing a known signature and compare those to the unknown signature in question.
And what are you looking for when you make that comparison?
I pore over the details of the signatures to look for similarities between the two. Similarities in the loops, the stroke direction, curves, angles, embellishment, you name it. I'm looking at it.
What documents with Mr. Donaldson's known signature did you use for your analysis?
I obtained Mr. Donaldson's signature from a copy of his life insurance that he'd signed at Summit Life and his driver's license.
And what did you compare those signatures to?
I compared the signatures to those documents to the signature on the will that Ms. Baja provided.
What did you notice when you did that comparison?
I noticed that the signatures were similar.
How so?
The loops, the strokes, the stroke direction, the angles, capitalization, the embellishment, they were all sufficiently similar to the other signatures.
Well, were there any differences between the signatures?
Yes, of course there were some differences.
And did they impact your conclusion?
No.
Why not?
In analyzing Lou Donaldson's signatures, there's bound to be some differences, but those differences were all inconclusive at best.
And why do you say they were inconclusive?
Well, signatures change for a variety of reasons. Age, health, even the kind of pen a person uses can change their signature and make it look different. That's why we all steal pens from restaurants.
Mr. Renard, can you direct your attention to the exhibit that's been previously marked as Bates number 007? Do you recognize this document?
I do, yes.
How do you recognize it?
This is the signature analysis I performed to determine the validity of the signature on Mr. Donaldson's will.
Is this a fair and accurate copy of that document?
It appears to be, yes.
And would it help the jury understand your analysis if they could see this document?
Absolutely.
Your Honor, at this time, I ask to enter Exhibit A into evidence.
Any objection to defense Exhibit A?
Your Honor, this exhibit has already been entered as Plaintiff's Exhibit 4.
Okay, so plaintiffs 4, defense A, same thing. It's previously admitted.
May we publish to the jury?
You may.
Thank you. And can you see that, Mr. Renard?
I can, yes.
What are we looking at?
These are the signatures I analyzed to determine the authenticity of the signature on Mr. Donaldson's will.
What is the signature that we see beside known signature 1?
That's Mr. Donaldson's signature on his life insurance policy.
What year did Mr. Donaldson sign that policy?
That was in 2005.
And what is the signature that we see beside question signature?
That's Mr. Donaldson's signature on his last will and testament.
And when was this signed?
That was signed in June of 2012.
How many years had passed between Mr. Donaldson signing his life insurance policy and his will?
7 years.
And is there anything significant about those 7 years in your expert opinion?
Well, Mr. Donaldson would have gotten older in that time. And like I said, changes in age can make a signature appear different. Also, it's very unlikely that Mr. Donaldson signed his will in 2012 using the same pen that he would have used at Summit Life in 2005, or even that that pen would still have ink.
Mr. Renard, in your opinion, was Mr. Donaldson's signature forged?
No, it's my opinion that Mr. Donaldson's signature on this will is genuine.
May I stop sharing my screen at this time?
You may.
As a forensic document examiner, was there anything else important to you about this will?
No, not in my role as a forensic document examiner, but as an investigator, I considered the language of the will.
Okay, let's switch then to your role as an investigator. First of all, why were you investigating Ms. Baja's involvement in Mr. Donaldson's disappearance?
Well, if Ms. Baja had been involved in the disappearance of Mr. Donaldson, there would be reason to contest the payment of his life insurance claim. Summit Life doesn't want to reward foul play, let alone murder, with large sums of money.
And what did you investigate to come to your conclusion that Ms. Baja was not involved in her husband's disappearance?
I looked at the language of the will, specifically the phrase, "if I should ever die or disappear." I looked at the timeline between Ms. Baja and Mr. Donaldson. The timeline between Ms. Baja had Mr. Donaldson declared dead, and when she filed her claim for the life insurance, and I looked at the police investigation of Ms. Baja.
Well, let's talk about some of the language of the will. Did you find anything unusual about the language in Mr. Donaldson's will?
Admittedly, yes. The will contained the phrase, quote, "if I should die or disappear." And in my 20 years at Summit Life, I'd never seen any language like that in a will before.
Well, if you found that language unusual, why didn't you recommend the claim be contested?
You would be amazed at the weird stuff people put in their wills. Plus, well, it was unusual when you take into consideration the timeline of his disappearance and the police investigation surrounding his disappearance. It seemed as though Miss Baja wasn't involved. She was just a bystander to this tragedy.
You've also been mentioning the importance of a timeline. When was Mr. Donaldson legally declared dead?
On August 18th, 2017.
And when did Ms. Baja file her claim with Summit Life for the payout of his life insurance?
The next day, on August 19th.
Well, was this unusual?
Not at all. It's not uncommon for claimants to file their claim on the first day possible. It wasn't any cause for concern.
Why wasn't it cause for concern?
Because considering how long Mr. Donaldson had been gone.
How long had he been gone?
He disappeared on August 17th, 2012, so 5 years. No one had seen him since. So it wasn't outlandish that Ms. Baja would file a claim the first day possible.
You also mentioned that you considered a police investigation. Where did you get your information?
From the sheriff's office.
What did you learn from the sheriff's office?
Objection, Your Honor.
Based on hearsay?
Yes, Your Honor.
What's your response to hearsay, Ms. Ward?
Your Honor, under Rule 703, experts may rely on otherwise inadmissible facts to come to their conclusion, and they may share those facts with the jury if they are substantially more probative than prejudicial, and further, if they help the jury to analyze and understand their opinion. In this case, the information that Mr. Renard learned from the police department was probative to whether or not Ms. Baja was involved in her husband's disappearance, which is also probative to whether or not he should contest the payment. That information would help the jury to understand his analysis, and therefore is not prejudicial to the plaintiff.
What did he learn from the police? Just so I have some understanding of the context here.
He learned that Ms. Baja was not involved, was not being looked at as a suspect in Mr. Donaldson's disappearance, that she had never been charged as a suspect or in that disappearance or in his murder.
Okay.
Sorry.
That's okay. Any response to that?
Yes, Your Honor. As counsel mentioned, in order to disclose the facts and data that an expert relied upon, these facts and data must be substantially more probative than prejudicial. And they have not tipped these scales to make it more substantially probative. This evidence is absolutely prejudicial for the simple fact that the information that the witness is about to testify to was obtained from a person who is unidentified, who we know nothing about. We know we will not be allowed to cross-examine this witness, and the jury will not be able to hear from this witness himself or herself. So we would argue that this is absolutely more prejudicial than probative, and we would argue that it should not be disclosed to the jury.
Okay, I'm going to overrule the objection. I think at this point, it's relatively undisputed that the first round of investigation came back where they didn't think Ms. Baja was involved. So I don't think that there's really much of a prejudicial value to this. And I certainly think it's reasonable that that Mr. Renard relied on the police department or sheriff's department's position that Ms. Baja had nothing to do with that as part of his investigation. So I'm going to allow it. But really, I don't think we need to spend a ton of time on it.
Yes, Your Honor.
Yes, Your Honor.
Mr. Renard, I'm going to ask you that question again. What did you learn from the sheriff's office?
I learned that Miss Baja, she had an alibi for some time covering Mr. Donaldson's disappearance, and that the rumors of her involvement were just that, rumors.
Were there any other factors that were significant to your investigation?
Yes, Mr. Donaldson's van was found at an airstrip, but there were no signs of foul play.
Please direct your attention to the exhibit previously marked as Bates number 0013. Do you recognize this document, Mr. Renard?
I do, yes.
And how do you recognize it?
This is a photo of the inside of Mr. Donaldson's van on the day that it was found by the police. I used it to come to my conclusions.
Is it a fair and accurate copy of those pictures?
It appears to be, yes.
Your Honor, at this time I ask to enter Exhibit B into evidence.
Any objection to B?
No, Your Honor, no objection.
All right, defense B shall be admitted.
Thank you. May I publish to the jury?
You may.
Are you able to see that, Mr. Renard?
Yes, I am.
What are we looking at?
This is the photo of the inside of Mr. Donaldson's van, and on the passenger side are his keys and his glasses.
Why was this significant to your investigation?
Well, there was no blood or sign of struggle in the van that we could see here, and everything really looks rather undisturbed. If anything, it looks as though Mr. Donaldson was just in a rush.
Mr. Renard, excuse me, was Ms. Baja ever named as a suspect in Lou Donaldson's disappearance?
No.
Was Ms. Baja ever charged with being involved in Lou Donaldson's disappearance?
No.
Was Ms. Baja ever charged with the murder of Lou Donaldson?
No.
No further questions at this time, Your Honor.
All right, thank you for that. Cross-examination?
Yes, Your Honor.
Whenever you're ready.
Mr. Renard, I'd like to talk a moment about information that you obtained from the sheriff's office.
Okay.
The sheriff's office actually refused to release any evidence of this investigation to you.
Well, I had access to all the depositions and all that information.
My question was whether the sheriff's office refused to release any evidence from the investigation to you. They didn't, did they?
I guess I wouldn't know if they did or not.
You wouldn't know if the sheriff's office refused evidence to you.
If they had evidence that I didn't get to see, then yeah, that's outside my knowledge.
So your testimony today is that you do not know whether the sheriff's office refused information to you.
If you say that they had something that I didn't get to see, then I guess.
I'm asking you, did the sheriff's office refuse to give you evidence?
Objection, Your Honor. Asked and answered at this point. It honestly appears that the witness may need to be refreshed, but he's answered the question.
I think he's answered the question. You can move to an impeachment if you wish.
Yes, Your Honor. Mr. Renard, You gave you submitted a report prior to this trial,
Yes.
and you knew that in that report you had to be complete.
Yes.
You knew they had to be accurate.
Yes.
You knew that you had to be truthful.
Yes.
Could you please see that report that you submitted to the court, submitted prior to this trial?
Yeah, I can find it. Okay. I have it pulled up.
Now, I'd like to direct you and the court to the fourth paragraph on page 1 of your report, specifically the second line of that paragraph. I'm going to read it out loud and you follow along with me. The sheriff's office has refused to release any evidence of Mr. Donald's disappearance to me for review, claiming the investigation is still active. Did I read that correctly?
Yes.
Now, the sheriff's office refused to release any evidence to you, but you did receive information from a source at the sheriff's office.
Yes, I did.
You can't tell us who that source is?
No.
You can't tell us what that source's name is?
No.
Tell us that if they're a law enforcement officer?
No, I cannot.
You have no personal knowledge of anything the sheriff's office did or didn't do?
I mean, I have knowledge of, like I said, all the reports that I've reviewed.
You have no knowledge of what the sheriff's office did or didn't do?
I have no knowledge of the evidence that they refused to grant me access to. I have knowledge of other things that they did and did not do.
The extent of your knowledge is the information you obtained from this source.
And the documents that I reviewed.
Is that a yes? The extent of knowledge is the information you received from the source.
No, that's a no.
So your testimony here today is that you received information from some other source other than the source you talked about on cross?
Objection, Your Honor. Asked to answer at this point. The witness has answered these questions.
Sustained.
I'd like to talk about a letter that you received. Samantha Lane was listed as an alleged will on the will you reviewed.
Yes.
You received a letter from Miss Lane.
Objection, Your Honor. This is outside of the scope of direct.
Overruled.
You received a letter from Miss Lane.
Yes, I did.
In that letter, Miss Lane shared some information with you.
Yeah, she did. Well, I don't know that it was Miss Lane. It claimed to be Miss Lane.
Well, there was a signature at the bottom of this letter.
Yes, but I also tried to reach Miss Lane and never could get a hold of her to verify this.
The signature at the bottom of this letter read Miss Lane.
Yes, the signature read Miss Lane.
Now, in this letter, you were informed, Your Honor, I plan to go into testimony that was covered in motions in limine. I'd like to, regarding the information that was shared in this letter to Mr. Renard, he has testified that he received a letter, and on direct examination, he stated that there was a witness to this will, Samantha Lane, and we would like to get into the language of a letter that he received from this same witness.
Your Honor, if I may very briefly, the witness never on direct examination said that he received a letter from Miss Lane or any correspondence from Miss Lane, nor did he mention Miss Lane.
So I don't think it matters that it wasn't brought up on direct. Pursuant to 611, you're allowed to go into anything that's relevant to the credibility of the witness. So this isn't a beyond the scope issue. I think this is more of an issue of hearsay. I think that's what you're trying to preempt then, Mr. Villarreal. Is that correct? A hearsay objection that we dealt with in motions in limine?
That's correct, Your Honor.
Okay, and so as I understand it, this is a letter from Miss Lane saying that she was under duress and wasn't really there for it, correct?
That's correct, Your Honor.
Okay, and this witness rejected that letter, right?
He did disregard the letter despite the information that he received in the letter.
Okay, so Miss Ward, what's your position then on the hearsay, since I didn't really clarify that until after I gave you a chance to respond? So I'm going to give you a chance to respond to the hearsay piece and your position on whether or not this can go towards his credibility of his investigation.
Well, Your Honor, first, because we don't know who wrote the letter, we cannot cross anyone about the authenticity of the letter, where it came from, whether or not it was truthful. And that alone, it makes it more prejudicial and probative, but also the statement is hearsay. It's an out-of-court statement by someone we are not even sure of. And for that reason, I would ask that it be excluded.
Okay, I'm going to allow it for a very limited purpose of just cross-examining the credibility of this witness. I certainly understand Miss Ward, your argument that we have no idea who this could have been. It could have been Karen Baj. I mean, like who knows who it was? You could certainly get into that on redirect. So I'm going to allow a very limited scope. I'll provide a limiting instruction to the jury that they're not necessarily to consider this statement for the truth of the matter, but rather a document that Mr. Renard completely disregarded in his report. Does my ruling make sense?
Yes, Your Honor.
Yes, Your Honor.
Okay, great. Whenever you're ready.
Mr. Renard, in this letter, you were informed that Samantha Lane, a witness to this will, was coerced into signing the will.
Yes, but there was nothing to corroborate that information.
She informed you that she never saw Lou Donaldson sign this letter.
The letter informed me that, yes.
I'm sorry, excuse me. She never saw Lou Donaldson sign the will.
That's what the letter stated.
And as you mentioned that you couldn't corroborate whether it was Samantha Lane, there was a signature at the bottom of this will, at the bottom of this letter.
Yeah, but I also tried to contact Miss Lane because she's recanting her testimony. So I tried to speak with her and could never get a hold of her.
You're a forensic document examiner.
Yes.
There was a signature at the bottom of this letter.
Yes, there was.
There was a signature by Samantha Lane on the will.
Yes.
You didn't compare those signatures.
No, I'm not going to place my blind trust in a random letter when I have verbal confirmation right out of the horse's mouth.
My question was that you did not compare these signatures.
No, I didn't feel it was necessary with a verbal confirmation from the observing witness.
Let's turn to the signature on this will that is purported to be Mr. Donaldson's. You mentioned that you obtained 2 signatures from Lou Donaldson?
Yes, one from his life insurance claim and one from his driver's license.
You compared those 2 signatures?
Yes.
There's no question that they're Lou Donaldson's.
No.
You compared those 2 signatures by Lou Donaldson to the signature on the will?
Yes.
There were some differences in those signatures.
Naturally, yes.
There were enough differences that your findings were inconclusive.
No, my finding was that it was a genuine signature.
Your testimony today is that this signature is genuine?
Yes.
Your Honor, recalling what's been entered into evidence as Plaintiff's Exhibit 4.
Okay. Are you trying to have it pulled up right now?
Yes, Your Honor, we're waiting on our tech to share the screen at the moment.
Okay.
Actually, I'll go ahead. Oh, here it is. Mr. Renard, you see Plaintiff's Exhibit 4 here on the screen?
Yes, I do.
I'd like to refer you to the notes at the bottom. Actually, first, there's a signature at the bottom of this document. Correct?
Yeah, my signature.
Now, I'd like to refer you to the notes. In the second sentence, please follow along with me as I read it out loud. I cannot say that the signature on the will is either genuine or non-genuine. Did I read that correctly?
You did. However, this was my initial notes. This didn't take into consideration the observing witnesses. These were just my initial observations, not my final conclusion.
I did read that correctly.
Yes, you read my initial observation correctly.
Now, in your words, the signature on the last will was just close enough.
It appeared to be genuine.
That was not my question. The question is that in your words, the signature on this last will and testament was close enough.
It was very close.
Is that a yes, sir?
Yes.
Pass the witness, Your Honor.
All right, Ms. Ward, redirect.
Yes, briefly, Your Honor. Mr. Renard on cross, opposing counsel brought up the sheriff's office. Excuse me, I didn't want to lead you. How did you get your information from the sheriff's office?
I spoke with a few people at the sheriff's office to obtain some information.
The opposing counsel also mentioned Samantha Lane and your investigation into her signature. I want to go back over your signature analysis. How many true signatures from Lou Donaldson how many true signatures from Lou Donaldson did you have to compare to the one on his will?
2.
And how many signatures did you have from Samantha Lane to compare to the one on the letter?
Just the one.
I'd also like to talk to you about your notes versus your report. So opposing counsel noted that in your notes, you said that you couldn't state if things were genuine or non-genuine. What were you able to state in your official report to Summit Life Insurance?
In my official report, I said that the signature appeared to be genuine.
Thank you, Mr. Renard. No further questions at this time. May the witness step down?
Yes, he may. Thank you, Mr. Renard. All right, does the defense have any additional witnesses?
Not at this time, Your Honor. Or yes, I'm so sorry, Your Honor. One more. Jesus, we do not. I'm so sorry.
That's okay. All right. Are there any motions that we need to take up at this time?
Not from the defense, Your Honor.
All right. Are we ready to proceed to closing arguments?
Your Honor, one moment as co-counsel comes in to make the closing argument.
That's fine. While she's doing that, I asked the timekeepers just to start preparing a time check so everyone knows how much time we have for closing argument. Plaintiff, do you wish to reserve any additional time should you have it for closing?
I believe I will leave that up to the co-counsel. I'm not sure exactly what her plan is at this moment. One moment to switch out, Your Honor.
No problem. And just timekeepers, let me know when you have time for us.
Sorry about that, Your Honor.
It's okay. Ms. Savant, are you going to want to reserve any time for closing argument or for rebuttal?
Yes, Your Honor, depending on what information I receive from the time check, if that's okay with you, I'd like to then make the decision after that.
Sure.
Thank you, Your Honor.
All right, plaintiff, it looks like you have used 61 minutes and 45 seconds. So you'll have, I'll call it 9 minutes for closing. And we will, timekeeper, just let me know. Do you want to have the timekeeper alert you via chat, or how do you want the timekeeper to let you know if you are running out of time? We do have to have a hard stop when you run over. I'm giving you a little bit of extra time by just rounding to 9. So let me know your position on what you want for time purposes.
Yes, Your Honor. If the timekeeper could let me know through the chat, that would be I'd be very grateful for that. Also, may I reserve 45 seconds for rebuttal?
Sure. We'll have timekeeper if you can send a chat when Ms. Samant has about a minute left. That would be great. And defense, how much time do we have left for defense?
We are still waiting for an answer, Your Honor.
Oh, poor Mr. Renard is the timekeeper, and he was testifying while I'm telling him to prepare time checks. Okay. 5328 used for the defense, so 17 minutes or so. Defense, I fully expect that you're not going to use that all for closing argument, but you should be fine on time. So Ms. Samant, whenever you're ready, and then we'll alert you when you have about a minute left, and you can use that for rebuttal.
Yes, Your Honor. Forgery, fraud, fortune. The defendant's forgery, the defendant's fraud, and now the defendant's fortune. Cam Donaldson is Lou Donaldson's only child, and she wants answers. But all the defense has is excuses. Cam Donaldson comes before you, members of the jury, so that you can do for her what she can't do for herself, and that is to hold the defendant, Karen Beja, responsible. You heard at the beginning of today's trial that my co-counsel told you, as the plaintiff in this case, the burden of proof rests with us. That is known as a preponderance of the evidence. And what that means at the end of today's trial, based on everything the plaintiff has presented, it is more likely that the explanation of what happened to Lou Donaldson and who is responsible is what the plaintiff has put forth. In order to prove our case to you, we have to prove 4 elements. First, that Lou Donaldson is dead. Second, that Karen Beja, the defendant, caused Lou Donaldson's death, either intentionally or recklessly. Third, that Cam Donaldson, the plaintiff, has suffered as a result of losing her father. And fourth, that Cam's suffering is because of Karen Beja's conduct. I don't need you to take my word for it, so I'm going to show you how the evidence has established that the plaintiff has met her burden. The first element that we have proven is that Lou Donaldson is dead. Although this is something that Cam never wanted to admit, the evidence only points in one direction, and the writing is on the wall. Lou is no longer with us. No one has seen him or heard from him since August 17th, 2012. His bank account sits untouched. He's never come back to see Cam. He's never come back to Wild Wild Life. The defendant had him legally declared dead, and she was fine doing that when it meant that she would obtain a fortune. But now that she sits in court and that fortune can be taken away, she wants you to believe he's still alive. The next element that we proved is that Karen Beja's conduct caused Lou Donaldson's death. And in order for us to understand this element, we have to go through everything that we heard. First, you saw a forgery. First, you saw a forged will that Karen Beja created. Now, this will leaves everything to the defendant, and this will was written June 14th, 2012. What is more likely? Is it more likely that while wanting a divorce from the defendant, and having filed a temporary restraining order against her just a few days earlier, that Lou Donaldson then decides that he wants to write a new will and leave everything to the person that he is afraid of and the person that he wants to divorce? Or is it more likely that the defendant saw that Lou Donaldson wanted out of that marriage and she wasn't going to let that happen? And this was her ticket to becoming the owner of Wild Wild Life. Not only are the circumstances surrounding this will suspicious, but the will itself doesn't pass muster. Now, you heard how wills have to be legitimate and how they have to be valid. You heard that Taylor Pride, an expert in signature identification, told you that Lou Donaldson's signature is forged. Now, she could tell you each step-by-step analysis. She could tell you how the pen strokes differed, how each stroke angled differently, and how each characteristic of a person's handwriting matters. The defense brought you a so-called expert. Now, he told you that he disregarded a letter that was extremely crucial to determining whether the will was forged or not. He didn't use his expertise in signature analysis to determine whether the evidence was credible. And most importantly, his findings were inconclusive. That literally means he can't give you an answer. Now, he got close enough. There were differences, there was reasons to deny this, but he got close enough. And he really needs you to believe that he's good at his job and he knows what he's talking about. But we know better. Also remember back to what Cam told you, what happened at Wild Wild Life shortly after Lou Donaldson was, disappeared. Now, Lou Donaldson disappears. Wild Wild Life is broken into. The will that's in the lockbox is taken. And Cam is fired. And from that point on, there's only a forgery. Now, aside from the forged will, you remember that there was a life insurance policy. Now, Ms. Beja wants you to believe that this 5-year period she had to wait for this life insurance policy is standard. But we learned today that 5 years does not start until someone reports someone missing. In this case, it started when Karen Beja, the defendant, reported Lou Donaldson missing. Even though Lou had been on trips before, Lou went all over the world and never told her where he was or for how long he was going to be gone. So why was this time different? We know why it's different. Karen knew that Lou's not coming back. You also heard from Exotic Bob. Now, Exotic Bob told you exactly what Karen threatened him with. She threatened him that if he double-crossed her, that there would be no mythical flights to Costa Rica. There would be no mythical flights to Costa Rica. She would do to him like she did to her husband, and she would feed him to her cats. The defendant had to admit that the police had been to her property and checked her meat grinder. And mind you, her alibi that night is her brother, who works at the Pioneer Sheriff's Department. The same sheriff's department that won't name his sister a suspect. The next element we had to prove to you is that Cam has suffered as a result of her losing her father. Now, there can be no doubt. Cam told you today how close they were, how long they worked together, and how she's never going to have this relationship back. The final element that we have proven to you is that the reason why Cam is suffering every day since August 17th, 2012 is because of what the defendant did. Karen Beja hadn't killed her husband. She wouldn't sit in front of you today a millionaire, owning a $5 million business, having collected on a $5 million life insurance policy. Karen Beja is responsible for why Lou Donaldson isn't here and why Cam suffers every day, why there's one less place setting at Sunday suppers. When you go back and deliberate, we ask that you choose verdict form A. You can put a value on Cam's suffering. And we ask that you award the plaintiff $11 million. Thank you.
All right, thank you. Defense, whenever you're ready.
Thank you, Your Honor. Your Honor, I just asked if opposing counsel can turn their camera off.
Yes, Ms. Simone, if you don't mind.
Thank you. Lou vanished because he wanted to. Lou Donaldson was an eccentric, self-made millionaire who spent most of his life living for himself, flying out of town whenever he wanted, driving a beat-up old van, even though he could afford much more, marrying a woman he picked up off the street, and building a tiger legacy just to abandon it all and leave chaos in its wake. Chaos that left his wife and daughter at odds with one another. On one side, his daughter Cam, left dealing with the hurt and despair of not only losing her father, but knowing that he didn't think she was quite right to continue his tiger legacy. And on the other hand, his wife, Karen Baja, left running the business all on her own while trying to protect herself from a family that outwardly hates her and wants to take from her what she helped build. All while Lou left without a word, a note, a wave, just a will detailing what to do in the event of his death or disappearance. So instead of Cam coping and honoring her father's wishes, we're here to discuss and decide on a wrongful death lawsuit brought by Cam against our client, her stepmother, Karen Baja. In a wrongful death lawsuit, the plaintiff, Cam, has 4 things to prove. They have to prove those by a preponderance of evidence, which means it's probably true than not. And throughout my close, the elements will be on my side. So we are going to dive a little deeper into each of those elements, but before we do, let's talk about instruction number 8 on your jury instructions. Do not speculate. Remember, in order to find for a plaintiff, there can't be any speculation. In other words, no guessing should be done on what happened. So when you review the facts in the jury room, ask yourself, did I hear cold hard evidence of this? Or am I just taking a guess at what happened? So let's talk about the elements. The first element, Lou is dead. You heard that there is a death certificate that says Lou is dead. Does a death certificate make someone dead though? Or is it just a legal process? In this case, it's a legal process. A piece of paper doesn't make someone dead. Karen sat waiting for 5 years for Lou to come back to her, for a chance to make things better, like they used to be. She didn't get that chance. She filed to have him declared dead so she could continue the tiger legacy her and Lou spent their lives building. And if Lou is dead, where's his body? Without Lou's remains, both Karen and Cam are left to wonder whether he's dead or alive. No evidence was presented today that Lou is dead, only speculation. And in addition to all the paperwork that Lou left Karen, Lou also left Karen to deal with vicious rumors surrounding his disappearance. True, with many disappearances, the onlookers always look to the spouse, which made Karen an easy target for Cam to use her as a scapegoat for all of her issues surrounding Lou's disappearance. Cam came up with baseless conspiracy theories about a meat grinder, but we heard no proof of that today, only speculation. No physical evidence, no circumstantial evidence, nothing. Karen had to have her life poked and prodded while she listened to whispers about murder behind her back and to her face. But the police department and the insurance company both came to the conclusion there was no homicide. So why are we talking about homicide? Well, this leads to our second element, that Lou died because of intentional or reckless conduct caused by Lou Baja. We heard from Cam. There's no doubt that Cam has suffered a terrible loss with her father's disappearance. In the beginning, Cam had to watch her dad move on after a marriage to her mom didn't work out. That's hard. It's natural for a lot of folks to dislike their stepmothers for this reason. Then when Karen came along, she always had to share with a woman who she sees took the place of her mom in her dad's life. Then having to deal with the fact that her dad left the sanctuary to Karen and Karen firing her, it's natural for Cam to want to scapegoat Karen. Karen seems to be the person that took everything from her in her eyes. But Lou is the one who left the sanctuary to Karen. Then Karen, knowing the disdain that Cam had for her, had to let Cam go because she'd already lost her husband. She couldn't risk losing her business to endless fighting. And as evidenced as us being here today, it was probably for the best, because we're left arguing over his will. But first, one of those issues that we are examining today is whether another will existed, a will that had no extra copies and no witnesses. Cam told us that the will was in the lockbox. We heard no proof of that today. The other alleged will that Cam told us about split the assets 4 ways between her mom, a wildlife foundation, and Karen. But with all of Lou Donaldson's faults, we can't deny that he was a smart businessman, a self-made man. Do we honestly think he would leave his legacy to people who hate each other? But let's talk about the will that we did see today. We heard from two experts today. The first expert was Taylor Pride. Miss Pride has an extensive history in law enforcement and handwriting analysis. She was hired to look into the surrounding circumstances and the handwriting on Lou's will to come to her conclusions. Miss Pride found a lot of things suspicious, but she didn't interview anyone in the case. She thought the police did a poor job investigating, but she didn't have access to the police reports. So she speculated. She also said that they did a bad job because they didn't find a body. She didn't find a body. Yet she concluded that Miss Baja was responsible for Lou's death. So unless Miss Baja killed Lou with her handwriting, it's doubtful that Miss Pride did a thorough enough investigation to go directly from forged document to murder. Also, Miss Pride doesn't follow her own rules. She told us today that an original, not a photocopy, is best for analyzing handwriting samples. But then she goes on to tell us how the photocopies don't match up. She had an original signature available with the letter to his children, but she didn't use that. How can we trust the conclusions that Miss Pride came to when she doesn't follow her own guidelines and she offers us no physical evidence? Just talk of suspicious circumstances. And let's get into those suspicious circumstances that Miss Pride reviewed. One of those suspicious circumstances was the fact that the will said death or disappearance. Both experts in handwriting and law enforcement said they've never seen disappearance written in a will before. But have they met anyone like Lou? We heard how eccentric Lou was, how he would take off on random air flights without a plan and without telling anyone. Lou left because he wanted to, and that is why he wrote "if I die or disappear" in his will. With the prospect of having another woman's arms he could crawl into in Costa Rica, Lou threw his old life away and started a new one. The plaintiff would also have you speculate that this isn't true because they haven't seen any bank withdrawals since the last month he was seen. We didn't see any bank statements before the month he was missing, though. No cash withdrawals, no money transfers. Who knows what planning or activity could have happened in those previous months? And a self-made millionaire who knows how to hide money. Who would have thought? Another suspicious circumstance alleged by the plaintiff was the restraining order and the divorce talks from Karen today. We heard from Karen today, and Karen loved her husband of 11 years. But please don't misunderstand. That does not mean that they were without their problems. There was talk of divorce. We'd be hard pressed to find a couple together as long as Karen and Lou and not find a couple skeletons in the closet. The truth is, though, after a court looked the situation over, they didn't find need for a restraining order. And what did Lou do after filing for the restraining order? Did he move in with Cam? No. Did he find a new place to live? No. Did he file for divorce? Also no. He continued to live with Karen in the home they shared for 11 years. Karen and Lou lived together until the day he decided to disappear. They slept in the same house and continued to run their cat sanctuary. And let's pause and take a tally here. We've heard from 3 trusted agencies that excluded Karen from any wrongdoing. The police department found no foul play and never investigated Karen. The insurance company paid the life insurance claim to Karen after an investigation, and the courts denied a restraining order because there were no real threats. And then we have one person who says she murdered Cam, or who says that Karen murdered Lou, Cam, who, if we believed, stands to gain millions. talk about the night that Lou went missing, the morning of August 18th. Karen was out in the early hours trying to get some milk for the Tigers. Then when her car broke down, she called her brother Carl, her police officer brother that she knew would be in the area because it's his district, and she knew he would be awake because it's his shift. She didn't call her husband because she never knew when he was going to be home. Lou was eccentric, untraceable, and unpredictable. Karen and her brother fixed the car problems and went home. The next morning is when things get strange. Karen was at the office getting a lockbox. And Karen didn't know where Lou was at this point. She didn't know if he had disappeared. So a very good question is, what the heck was Karen doing at the office? Well, Karen told you that while her and Lou had their disagreements in the past, this time was different. Lou had a girlfriend. Lou had divorce talks. Lou filed a restraining order. Lou wrote disappearance in his will. Lou all but told Karen, "This is it, I'm leaving." So this time was different and Karen needed to act. Cam outwardly hated her and Karen had to protect what she helped build. She went to the office to get the lockbox of papers. Cam says the lockbox contained a will, but no one else does. Only Cam. No other evidence. Cam, the person with the millions reasons to lie and blame Karen. Like I mentioned earlier, we heard from two experts today. The other expert was Chris Renard, a person certified by the Forensic Document Examiners Association and by the certified and he's a certified fraud specialist. Mr. Renard wasn't just a one and done. He makes sure to stay up to date yearly. He told us that it's unlikely that the will is a fake and it appears to be genuine. He came to those conclusions that the signature on the will was close enough to Mr. Donaldson's known signature to warrant a finding that Mr. Donaldson signed that will. Two competing experts, one that doesn't follow their own rules and jumps to conclusions, and one that has an extensive history in signature recognition and doesn't make brash conclusions. Mr. Renard is more believable here. This brings the second element to a close and proves Lou did not die because of intentional or reckless conduct by Ms. Baja. And very briefly, the last two elements, which relate to what we've already discussed. First, Cam hasn't proved Lou dead. It's no doubt that Cam has been emotionally hurt by the disappearance of her father, but it's not because of Karen's actions. Cam can't be injured by something that was never hit hers. Cam's father chose to disappear. Cam's father chose to leave his beloved cat sanctuary to Karen. That was Lou's choice, not Karen's. Lou was a man always ascending in life at the expense of others. He was eccentric, unpredictable, and selfish. He was a millionaire that made his daughter and wife do most of the work. He picked up a woman off the side of the road and married her despite the family hating her. He flew out of town whenever he pleased, not telling a soul. Not even telling the people he was legally obligated to tell. Lou's unpredictability knew no boundaries. And although Lou led a selfish life, we have to respect his wishes. Cam and Karen have to honor his wishes. The one decent thing Lou did was leave a will that can give closure to Lou's selfish lifestyle. Even though he worked mostly for himself, Lou loved those cats and he knew Karen would be best person for them, not Cam. And something troubling at trial today, Cam doesn't know. Cam doesn't know if she worked with Karen. Cam didn't know if she owned wild wildlife. Didn't Karen fire Cam? She didn't know a lot about Cam. Or honestly, she didn't know a lot about Karen and honestly about her own actions. Members of the jury, what does Cam know? How can her conclusions be trusted when she didn't even know where or when she worked or who with? She couldn't even tell us some specifics about the time with her dad. And another troubling thing at trial today, Exotic Bob. The plaintiff brought Exotic Bob to help their claims today. A prisoner who sang you a song. A man with a revenge motive. Believing Exotic Bob is a dangerous speculation. Lou's selfish behavior ends with you today. A decision that can put these conspiracy theories to rest so a family can truly find closure. There are some mysteries in this case, but mystery does not equal murder. Lou Donaldson disappeared because he wanted to. We ask that you honor his wishes for his wild wildlife cat sanctuary. We ask that you do what Cam is not able to do, not speculate. We ask that you find for Karen Baja. Thank you.
Thank you. Ms. Saban, I believe you have about 1 minute and 30 seconds left.
Oh, is Your Honor okay with me using the entirety, although I only reserve 45 seconds?
Oh, yeah, use your 1 minute and 30. And I will just stop you when you're there.
Yes, Your Honor, if I may just have one brief moment.
Yep.
Members of the jury, you just heard from the defense, and all they told you is that this case comes back to forgery, fraud, and Karen Baja's fortune. No matter where they try to steer you and distract you and divert your attention, it always comes back to that. It doesn't matter that Karen Baja doesn't want to take responsibility for her actions. She has to. If anything ever happens to me, be sure to have the police look into Karen, because she will be the one responsible for my death. These were Lou's words. We ask that you honor Lou's words and that you honor Lou's wishes and find the defendant liable, because the defendant is liable for causing Lou Donaldson's death. Thank you.
All right, thank you. That concludes our trial for the day, for the evening. We will submit the case to the jury.